Good afternoon. The first item of business is a debate on motion number 8145 in the name of Rosanna Cunningham on the Tribunals-Scotland-Bill. Members who wish to take part in the debate should press the request to speak button now. And I call on Rosanna Cunningham to speak to and move the motion. Minister, you have 14 minutes.
Thank you, Presiding Officer. I'm delighted to be opening this Stage 1 debate on the Tribunals-Scotland-Bill. And I'd like to take this opportunity to thank the Justice Committee for their scrutiny of the bill at Stage 1 and for the preparation of their comprehensive Stage 1 report. I'd also like to record my thanks to the various groups and individuals who provided evidence to the Justice Committee during Stage 1, as well as those who have engaged directly with us during the development of the bill and the parliamentary process to date. As every member in this chamber knows, that the introduction of the bill is usually preceded by a considerable amount of work that has probably gone on for a good couple of years prior to that. And those folk who are engaged in that discussion have then got to carry through during the process of the bill itself. Now, the aim of the Tribunals Bill is to create a simplified, flexible framework that will provide coherence across the current disparate tribunals landscape. It brings improvements to the structure, management and organisation of devolved tribunals, whilst maintaining the specialism and ethos of each individual tribunal. The bill creates a simple two-tier structure, introducing some common practices and procedures and brings judicial leadership under the Lord President. The bill includes proposals to bring tribunal appointments into the remit of the Judicial Appointments Board for Scotland. This will ensure independence from government and will provide consistency in tribunal appointments. This will ensure that all tribunal users will benefit from the same high standard of judicial decision-making, regardless of the subject matter. The bill also creates the office of President of Scottish Tribunals to support the Lord President with his new duties, to champion tribunals in the wider civil justice system, and to ensure the proper distinction and separation of tribunals from courts. There will also be a new upper tribunal for Scotland. This will benefit the tribunal user by removing, in most cases, appeals from courts. The bill creates a structure which will enable a far better service to be provided to those who use it, and it deals with structure and organisation, and much of the detail will therefore necessarily be fleshed out in secondary legislation. However, the proposals in the bill have not been developed in isolation. In addition to the formal consultation exercise, we have engaged extensively with stakeholders and the judiciary. It's also important to note that the bill is an integral part of our wider Making Justice Work programme. It doesn't sit in isolation. The programme represents the most significant set of reforms to our justice system for more than a century. Making Justice Work brings together a wide range of reforms to the structure and processes of the courts, access to justice and tribunals, and administrative justice. It has been developed and is being delivered with partners across the justice system, although it's probably fair to say this is at the least controversial end of that broader programme of work. Turning to the detail of the Justice Committee's report, I warmly welcome their support for the general principles of the bill and their recommendation to the Parliament that they be approved. I will address a few of the issues raised in the report in this opening speech, and I'll be interested in hearing members' views during the debate. I note the committee's view that consideration should be given to extend the pool of eligible candidates for assignment to the office of President of Scottish Tribunals. I think it's important to acknowledge that the leadership for the new tribunal structure will be vested in the Lord President. The Lord President will have the responsibility for the efficient disposal of business and will have overall responsibility for the Scottish tribunals, as he does for the Scottish courts. The position of President of Scottish Tribunals is not an appointment. It is an assignment by the Lord President to assist him in delivering these new responsibilities. And the President of Scottish Tribunals has certain functions delegated to them in the bill and will be responsible for the day-to-day running of the Scottish tribunals. This includes the upper tribunal, which will be made up of senators, sheriffs principal, sheriffs, as well as chamber presidents from the first-tier tribunal. For these reasons, I think it is entirely appropriate that the President of Scottish Tribunals is assigned from among the Senators of the College of Justice, and I welcome the Lord President's announcement that he intends to assign Lady Smith to this office. Lady Smith will bring a wealth of knowledge to this position. Now, of course.
John Finney.
I'm grateful for the Minister accepting an intervention. Minister, you're talking about it being not an appointment but an assignment, but there is a public expectation that the post and person specifications would be clearly laid out, as with other public appointments. Do you not see a merit in that?
Minister.
Well, what we want to do is to ensure that the Lord President is the one whose role is paramount in this. And I think that people need to keep that in mind. I don't want to get into the business of starting to define all the way down the line in the way that might be suggested by the member. But no doubt, if that's not what he means, he will come back to this afternoon. Leading on from that, and it does lead on rather from it, there has been some debate on whether the term judge should be specified in the bill. I note that it has been suggested by some that legal members on tribunals should be called tribunal judges, so as not to imply that they have a lesser status than court judiciary. But all members of tribunals are taking judicial decisions. Therefore, all members, whether they be legal or ordinary, should have the same status. And the bill achieves this aim by giving all members judicial status and capacity. This bill is designed to create a new structure for devolved tribunals. I am not aware of any devolved tribunals who currently use the term judge. And we must not forget that users are at the centre of what we are creating. I am aware that the term judge is not popular with the majority of tribunal stakeholders who fear a drift towards courtification, which may or may not be an actual word, presiding officer, but people do understand what it means, and a more adversarial approach to tribunal hearings. It is, however, for individual tribunals to determine what they call themselves during hearings informally. So that does not need to be explicit in the bill. However, I look forward to hearing members' views on this issue during the debate. There has been interest throughout the development of the bill, from consultation to the committee evidence sessions, that the particular nature and characteristics of the individual tribunals should be protected in the new structure. And if anything, that has probably been the prevailing sentiment expressed to us all in one way or another. I fully agree with this view, and I'm confident that we've ensured the right balance in the bill. The bill has to be flexible enough to allow the new structure to accommodate the different tribunals. By providing adequate safeguards, we ensure that each tribunal's specialism and ethos is protected. The committee has recommended that an amendment is made to the bill at stage 2 to allow for permanent members of the tribunals. While there is no need for permanent members now, I accept that this might be a requirement in the future. I am therefore intending to make an amendment to allow for permanent tribunal members should the need arise. I hear the convener of the committee sighing. I suspect I may have already dealt a blow to part of her speech. Of course.
Ms Graham.
I shall say this very slowly. I am amending parts of my speech.
Minister.
I thought that might be the case, presiding officer. Members do need to keep in mind that each tribunal has, of course, been created by its own particular Act of Parliament. They are all required to operate differently depending on the matter they're addressing. And this will still be the case in the new structure. For instance, the Lands Tribunal charges fees, so the bill contains provisions to allow that to continue. There has been some concern expressed about provision made in the bill for court judiciary, sheriffs, to be able to act as members of the first-tier tribunal. Well, there's a requirement in the Mental Health Act for the Mental Health Tribunal for Scotland to have a sheriff convener to sit in their forensic cases. Therefore, we have to allow recognition of that position in this legislation to ensure that sheriffs can act as members of the First Tribunal for that purpose. The bill allows Scottish ministers to make composition orders specifying which category of members hear what cases in matters that fall to the first-tier tribunal to determine. The judicial members, the sheriffs of the first-tier tribunal, will only appear on compensation orders for cases where the founding legislation requires them to sit. This ensures that they cannot hear any other type of case in the first-tier tribunal. It is possible that in the future there is a new jurisdiction created that also has a requirement for a judicial member to be part of the panel hearing the case. And remember, that would be in the set-up legislation, and will have been a policy decision taken within the context of the particular policy area. That wouldn't be my decision or come out of the Justice Department. The bill, as drafted, allows for this flexibility with safeguards in place to ensure judicial members of the first-tier tribunal are only authorised to hear cases where there is a genuine requirement for them to do so. The committee has suggested that there is merit in setting out the characteristics of a tribunal in the bill. As I indicated to the committee in my evidence, this is something I would be only too happy to consider. And therefore, I'm open to hearing members' views this afternoon as to how that might be constructed and what things they might like to see included in that. There have been representations by stakeholders that the Lands Tribunal for Scotland and the Mental Health Tribunal for Scotland should be treated differently in the bill. The Lands Tribunal by being a separate pillar out with the structure, and the Mental Health Tribunal by it having its own chamber enshrined in legislation. I fully appreciate the complexity and unique nature of both these tribunals. I will talk more about them individually in a moment. The key word in what is proposed in the Tribunals-Bill is flexibility. The structure is designed to allow it to develop and grow, responding to the needs of the individual tribunals transferring into it. The structure protects and maintains the unique individual needs of tribunals, as well as providing the benefits I mentioned earlier. It is true that the Lands Tribunal for Scotland deals with complex matters of law. It is also true that the Lands Tribunal operates extremely well. That is also true, however, of many other tribunals that will transfer into the new structure. Nothing proposed in the bill will affect how the tribunals operate in accordance with their founding legislation. I have taken account of the complexities of the Lands Tribunal by stating in the policy memorandum that its functions and members will transfer into the upper tribunal, with its appeals going to the inner house of the Court of Session, as they do now. It has been acknowledged that being in the upper tribunal would work for the Lands Tribunal. Being in a separate pillar doesn't provide anything that is not achieved by the Lands Tribunal's position in the new structure. Turning now to the Mental Health Tribunal, it is the only tribunal currently listed to come into the structure that makes decisions on people's liberty. The tribunal focuses on the needs of the patient, putting them at the centre of everything and ensuring that it is their voice which is heard by those who make decisions about their care and treatment. I fully agree with those who are strongly advocating for the retention of the specialism and ethos of this tribunal. I do not believe that anything we are proposing would be to the detriment of those values. The bill provides many safeguards, but most importantly, it does nothing to change the tribunal continuing to adhere to the Milan principles, which the Scottish Government believes are at the centre of everything the tribunal does. I have made the commitment that the Mental Health Tribunal will be in a chamber of its own in the first instance. The bill is clear that only similar subjects can be located together in chambers. There is currently nothing of a similar nature that can be located with the Mental Health Tribunal. There may never be a jurisdiction that could be located with the Mental Health Tribunal, but the bill as drafted is flexible enough to allow for that to happen if one should come along. Any changes to chamber structure will only be made following consultation and by affirmative order by this Parliament. And I'd also like to clarify, in case there is any misunderstanding, that two or more jurisdictions being located in the same chamber in no way amalgamates them. Each jurisdiction will continue to have their own founding legislation, their own specialist members, their own procedural rules and specialist support staff. All they will share is a chamber president. There are other issues that the committee have commented on that might be of interest to members in this chamber, and I'm looking forward to the debate and will seek to address any matters that arise in my closing remarks. This bill represents a long overdue reform of the tribunal landscape in Scotland, and one I sincerely believe will be to the advantage of all tribunals and their users. In conclusion, Presiding Officer, I welcome the wide support for the bill to date. I look forward to a constructive debate today on the creation of a cohesive tribunal structure for devolved tribunals in Scotland, and I move the motion in my name.
Thank you, Minister. If codification is not a word, it should be. I now call on Christine Graham to speak on behalf of the Justice Committee. Ms Graham, you've got 10 minutes.
Heavens. Thank you very much, Presiding Officer. It says here I welcome the opportunity to speak in this debate. I think that might go a bit too far, but I am speaking on behalf of the Justice Committee, who were the lead committee in considering the bill. And I thank, like the Minister, all those who gave written submissions and oral evidence to the committee. The difficulty, and I'll get this wee moan in first, Presiding Officer, is that the Minister of Cabinet Secretary gets to speak first, which completely undermines all the things we raised in our report. I wish it was the other way around, but I have no power. The purpose of the bill is to create, as the Minister says, a system to improve the independence and facilitate improvements in the quality of service to tribunal users. So it's a very worthy but somewhat dry and technical bill, so I've dressed to distract. And given that I'm yet again allocated vast deserts of time, 10 minutes, when there's not much to say except repeat and repeat and repeat, I have huge sympathy for those who follow, but there you go. I would call this a tumbleweed debate, but there was one worse in the year 2000, which was the reform of district courts. Look it up. Nothing could have been drier than that. I'm sure Mr Stevenson's going to tell me of an even greater tumbleweed debate.
Mr Stevenson.
Presiding Officer, I wonder if the member remembers the Court of Session Act of 1693, which specifically says that no person shall presume to speak after the Lords begin to advise. Perhaps that may be guidance as to the order in which we should be speaking in this place, since I'm sure the convener of our committee stands above us all.
Well, I like the last bit, but the idea that was around in 1693 was a bit wounding. By way of introduction, however, I'll take you through a brief journey, the very mixed landscape of tribunals, and for the purposes of this debate and indeed the legislation, these will be the devolved areas, which of course is only 2% of the entire total. These range from the Additional Support Needs Tribunal, which considers references made by parents and young people against decisions by local authorities regarding additional support for their learning needs, and will in certain circumstances hear placement requests. I have to say, some years ago, and I know it's improved since then, I attended one of these with a constituent to find the council armed to the gunwales with solicitors and parents only having me there, and a silenced me on their team, which was not very balanced and quite intimidating. There's also, at the other end, the Mental Health Tribunal, considering, as the Minister said, issues of compulsory detention under the Mental Health Act, taking away individuals' rights. But the Private Rented Housing Panel, I know you're all familiar with these, but many aren't, sitting about resolving issues between landlords and tenants, and the Homeowner Housing Panel, which aims to protect homeowners by providing minimum standards for property factors, and broadly also land managers. Now, many people don't know about these until they have to use them. Go on the internet, have a problem, find out these things exist. So it's all pretty nitty-gritty, basic and practical stuff, involving quite often the citizen and the state in the form of the local authority or indeed any other organisation. Then, if you like, at the other end, as the Minister has already said, the Lands Tribunal, which is really more like a court in its processes and culture. So, as I've said, a very disparate and good reason for the bill to draw them into some structure order, because many have evolved over time, while maintaining the range of processes and, of course, the culture of the informal of some and the very formal, perhaps, of the Lands Tribunal, while building in accessibility and maintaining a firm line. This is important, a firm line between tribunals and courts. The committee supports the general principles of the bill. However, we highlight a number of areas which the Minister has already sabotaged that could be improved to ensure that the balance is achieved between streamlining the current system without losing individual expertise within the existing tribunal. I've referred to reserved tribunals. These are not included in the new structure, and the UK Government has put on hold plans to devolve these for the time being. Devolved tribunals, I repeat, my first but not last repeat, only account for around 2% of Scottish tribunals, and so witnesses, including the faculty of advocates and CAS, Citizens Advice Scotland, recommend that these also be included to ensure the effectiveness of the system and make the process clearer for user. Judicial leadership, we welcome the designation of the Lord President as head of the Scottish tribunals and agreed this would bring strong judicial leadership across the system. However, we did have concerns already referred to for the appointment of the post of President of Tribunals, who will be appointed, though I think it was called assigning, I'm not quite sure, there was another term used. Assignment, there we are, thank you very much. And will be responsible for the efficient disposal of tribunal business. Currently, only a senator of the College of Justice can be assigned, and some witnesses felt this was overly restrictive. Now, I would add that this does not in any way reflect on the proposed assignment of Lady Smith QC. Independence. We welcome the objective of the bill to ensure a greater degree of tribunal independence, which will be brought about by the new structure. This is particularly the case for evaluation appeals committees and education appeals committee I've already referred to. In the membership, some witnesses raised questions about the nomenclature used to describe legal members of tribunals. I think we made a bit of a fuss about that. I'll just read that a bit in to see if you're awake. The Lord President argued that legal members should be referred to as judges to afford them the same status as court judiciary. On the other hand, other witnesses, such as the Law Society and the Employment Tribunal, argued this would make tribunals too court-like. What was the word we agreed on? I forgot. Courtified. Courtification. I'll need to develop adjectives and adverbs now. We concluded that this is a matter for individual tribunals to determine, and so we recommended that provision be made in the bill to give tribunals this flexibility. The bill also allows judicial members to act as members of the first tier and upper tribunals if authorised to do so. If you don't know what we're talking about with upper and first tiers, you'll need to look at the briefings on it, or somebody else in here will explain. I'm looking round at colleagues. I'm not too hopeful then by that sound. Once again, we were concerned that this would lead to over-judicialisation, I think that is a word perhaps, of the tribunals, making them more formal. The court judiciary may not have sufficient specialised knowledge and experience of tribunal work to carry out this role. That was a concern. The impact this could have on the diversity of appointments to tribunals, replicating the current gender and other imbalances when the judiciary, I think an issue that I think Margaret Mitchell may develop. I've got a feeling I've pressed a button there. Although the committee concluded that the nature and characteristics of tribunals should be protected, we also recognise the benefits of the provision. We therefore concluded that this would be applied effectively using the President of the Tribunal's discretion, with possible consultation with the relevant Chamber President. And as I said, I'll leave others to explain about chambers. Now, the definition of a tribunal is a tricky one, because there is an issue about protecting particular characteristics and natures of a tribunal. A number of witnesses suggested a definition should be included on the face of the bill. And I'll give you an example. We should need me talk for 10 minutes. The Scottish Committee of the Administrative Justice and Tribunals Council, they defined a tribunal as, and I quote, a body which resolves disputes between citizens and state and between private parties by making binding decisions according to law, does so by a process of adjudication which is specialised, relatively informal and less adversarial as compared to the model of adjudication applied by the courts, and is independent of both the executive and the legislature and of the parties appearing before it. Close quotes. So there's a proposed definition. I know that in the response of the Minister, which I have taken the trouble to read, she was looking at the Tribunals Act of 2007, Section 2, subsection 3, just to let the Minister know I read her response. And that's one that other members may wish to develop. But the challenge of the bill, of course, is to not only strike a balance between establishing a unified structure, but to retain the unique features of tribunals, all of the different kinds, and also have the perception, I think, of doing it, because I think some of our witnesses were concerned that the perception might be the same. So, practice directions, I'm getting through it. We welcome the Minister's commitment to bring forward an amendment to review the provision in section 68(5)(a), which enables the issuing of practice directions for the purpose of, quotes, the application or interpretation of the law. That was a bit we didn't like, and I think, if I remember correctly, the Lord President didn't like that either. So I'm in a good team in supporting that. So, in conclusion, are you still with me? They're all awake, which is quite a big plus. We support the bill. We welcome its objectives of bringing about a greater degree of tribunal independence, as well as ensuring the greater accessibility of tribunals to users. We've identified issues which, to some extent, the Minister has addressed, I'm sure that other members of the committee are itching to pick up some of the aspects of this bill I've not had time to cover. I look forward to hearing other contributions today and to the inventiveness of colleagues in trying to say something additional in the next coming 2 hours. Thank you very much.
Thank you, Ms Graham. It might be helpful to members if I advise that we have a little time in hand. So if you were to take interventions, the presiding officers will certainly allow you the additional time. I now call on Elaine Murray. Ms Murray, you've got 10 minutes.
Thank you, Presiding Officer. The Scottish Parliament has over the years debated many bills which have attracted significant media and public attention. Bills which have given the entitlement to permanent housing to the unintentionally homeless, banned fox hunting, smoking in public places, or more recently addressing climate change and reforming Scotland's police, fire and rescue services. But I don't think this Tribunals Bill is one of those bills which will get everybody talking. It is, as others have already said, relatively uncontentious in its general principles, though there are concerns about aspects of detail, which I will come on to later. But, despite the lack of major areas of discard, I actually found the committee's 3 sessions of evidence gathering from the witnesses surprisingly interesting, and I can't promise that either of my speeches, because unfortunately there is more than one today, are actually going to be interesting to the same extent, but I certainly thank the witnesses for their contributions. In many respects, the legislation mirrors that contained in the provisions of the UK Tribunals, Courts and Enforcement Act of 2007, which applies to tribunals in England. And for the same reasons, tribunals have evolved through separate pieces of founding legislation without a coherent system of review and appeal, with a varying variety of processes for appointments and opportunities for training. So the legislation aims, therefore, to bring coherence at this stage to the devolved tribunals in Scotland and to provide opportunities to benefit from shared good practice and expertise. However, because at present the UK Government is not minded to transfer the reserved tribunals such as employment tribunals, immigration or the social entitlement chamber into the Scottish tribunal system, this legislation, as Christine Graham also already referred to, will only apply to, I think it's, well, one of the witnesses said it was 2% of Scottish tribunals, and others said 3%, so I think it's somewhere between 2 and 3%. The vast majority will remain at the moment within the reserved tribunals system. Jonathan Mitchell of the Faculty of Advocates advised us that the proposed system would apply to around 4,000 cases annually in Scotland, while 60,000 will go through the social entitlement chamber, 20,000 to Scottish employment tribunals and 10,000 to immigration and asylum tribunals. So at the moment we're dealing with a small number of cases. One of the issues brought to the committee's attention was, as this legislation will apply not only to the existing devolved tribunals but to the reserved tribunals if and when they transfer, and any new tribunals which we may decide to set up in the future, is, as others have already said, that it should contain some form of definition of the character of a tribunal. A suggestion from Lauren Wood of the Citizens Advice Scotland said that actual principles to help guide tribunals are included in the Tribunals, Courts and Enforcement Act of 2007, and those could be incorporated into the bill, and that may be a starting point for us at stage 2 to consider how this bill might be amended. John Shaw of the Child Poverty Action Group felt that despite similar provisions being contained in the Scottish Civil Justice and Criminal Legal Assistance Act 2013, the placing of a principle in this bill would be a real improvement. Richard Henderson of the Law Society advised that when making reforms in different areas, such as civil courts and tribunals, you will have to ask yourself about the linkage between them, and then asking that question then prompts a question, what actually is a tribunal? The argument for having the principles defining the nature of a tribunal in the bill does not contradict the fact that the existing devolved tribunals will have and do have distinctive characteristics which the new system must preserve. Certainly.
Stuart Stevenson.
I wonder if it would be helpful to look at the way Spices actually described what a tribunal is, because it seems to me that it captures it very well. And it says very simply, most tribunals deal with disputes between individuals and the state. So therefore, we shouldn't downplay the importance of tribunals, because they are ultimately that quasi-judicial way that individuals can make sure that their rights are protected and the state does not become too dominant. So probably that's as good a definition as I've seen.
Ellie Murray.
Indeed, I thank the member for his intervention there. That was along the lines of some of the suggestions which were made to the committee, and I certainly think we will be keen to pursue some of those later, because although we all think we know what a tribunal is, you cannot be, that's not good enough when you're actually dealing with matters of law. Witnesses speaking at the committee were also anxious that the specialisms of these tribunals should not be lost, and that the individual tribunals should be placed within the appropriate tier, pillar or chamber to ensure that expertise and character are maintained. The policy memorandum accompanying the bill states that the Scottish Government has, and the Minister referred to this, made a commitment that initially the Mental Health Tribunal will be in a chamber on its own, because at the moment there are no tribunals covering a similar subject. The Mental Health Tribunal itself is satisfied that the new structure will not compromise its expertise, ethos or the substantive mental health law. However, some witnesses felt that the provision for this initially was insufficient as a guarantee. Adrian Ward of the Law Society pointed out that 5 years ago, and I quote, "a significant change in the status of the Mental Welfare Commissioner almost slipped through in the context of the Public Services Reform Scotland Act." The Law Society therefore argued that the bill itself should state that the Mental Health Tribunal should be in a chamber of its own. Any change to this arrangement, they argue, would therefore have to be made by Parliament, and that was a stance which was met with the agreement of Alan Gamble, who had been a convener of the Mental Health Tribunal. I wonder actually, and this I've only just thought about this, whether there's some form of compromise which would actually enable the status to be introduced through a statutory instrument, which would mean there would be parliamentary scrutiny of change, but it wouldn't actually require amendment to the primary legislation. So I just wonder whether we could maybe look at along those lines at stage 2. The positioning of the Land Tribunal is also a matter of argument. Again, as we've already heard, the bill places the Lands Tribunal in the upper tier, and that is analogous to the position of the Lands Tribunal of England and Wales under the UK 2007 Act. However, the Lands Tribunal of England and Wales is substantially an appeals body dealing in a large part with valuation appeals, and therefore it sits comfortably within the upper tier. The Lands Tribunal in Scotland, if you go onto its website, describes itself as effectively being an independent civil court dealing with disputes involving land or property. Lord Gill told the committee that the Lands Tribunal is, and I quote, a court of law in all but name, and that it has no appellate functions of any kind, with appeals from there going to the Court of Session. He stated that the Lands Tribunal is not broken, and I don't think anybody was saying it's broken. I think it's actually about the structure of the tribunal system themselves. And it does not require fixing, he thought, and he believed it should be left in a separate pillar on its own. And as the Minister has indicated, she wasn't supportive of that suggestion. I think that's for understandable reasons, because it would appear to run contrary to the purpose of the legislation to bring devolved tribunals together within a coherent structure, and then you start making exceptions and sticking different tribunals outside. But I think there might be a more fundamental question regarding whether the Land Tribunal is, despite its name, actually a tribunal. And this might be where a definition in the bill could be of assistance. Because despite its name and being one of our oldest tribunals, if it is, as Lord Gill advised, in all but name a civil court, perhaps it should be part of the civil court structure than the tribunal structure. In which case, it could be argued that leaving it in a separate pillar for the time being until its status is resolved could be a temporary solution. And I think that, again, is something we may wish to return to at stage 2. The bill also contains provision for tribunals to award expenses and to charge fees. As members will know, this has been a contentious feature of the employment tribunals, which recently introduced significant fees of £160 or up to £250 to lodge an appeal, and a further £230 or £950 if the case goes ahead. These charges have been subject to judicial review in the High Court last month as a result of a challenge from Unison. The Minister advised the committee that the provisions of Section 70 were necessary because some tribunals do already charge fees, and the Scottish Government Solicitor Michael Gilmartin further advised the committee that any proposal to charge fees where they had not been charged previously would be required to come to Parliament for approval. Now, my understanding is that this would be under a negative procedure, and again, it might be worth considering whether, in order to increase the level of scrutiny of any proposals to introduce fees, that this should be by affirmative rather than negative instrument. Section 59 has also given tribunals the powers to award expenses. Lord Gill told us that he believed that this would not be a regular event, as it is not generally a feature of tribunal decisions now, and it would only be used in exceptional cases. Subsection 3C makes a curious reference to wasted expenses, which Lord Gill pointed out was not defined. And at the committee, I was relieved to hear that the Minister stated in her evidence that she was not quite sure what was meant by any wasted expenses, as I had no idea whatsoever what it meant. And I wonder if it is used, whether we do need to have some sort of definition, because even the government solicitor didn't seem to be terribly sure either, although he said that a definition could maybe be set out in procedural rules. The convener has made reference to section 68.5 bill of the 68.5 of the bill. This gave rise to considerable consternation amongst witnesses, as it gave the President of Tribunals the power to issue directions, including instructional guidance, on the application or interpretation of the law. Those witnesses felt it was quite inappropriate for the interpretation of the law to be made by a senior judge acting administratively rather than judicially. Fortunately, this has turned out to be a drafting error, and the Minister, I know, intends to correct this at stage 2. A number of other issues were raised in our evidence-taking, which others may refer to. The sift for appeals to go to the upper chamber, and whether it was necessary for this to be as high as it's set. Again, this appears to have been based on English and Welsh legislation, where it was designed to exclude a flood of vexatious requests for review. Also, whether the first-tier tribunal should be able to refer a case to the upper tribunal, not just on a point of law, but on the whole case, facts and law. Salaried posts were felt by the Minister to be unnecessary for the operation of the devolved tribunals. Some witnesses argued that it would be helpful to put the provision for this into the bill in readiness for the transfer of the reserved tribunals, which will generate a far greater workload and may necessitate full-time salaried positions. The committee agreed that the bill should allow for this possibility should the need arise in future. And I'm pleased to say that it's nearly 11 minutes gone, and therefore I will say in conclusion to this speech that I'm looking forward to the debate and indeed to our discussions at stage 2.
Many thanks. I now call on Margaret Mitchell, 7 minutes or thereby, please.
Thank you, Presiding Officer. Tribunals are an important part of our civil justice system, so I welcome the opportunity to speak at this stage 1 debate on the general principles of the Tribunals-Scotland-Bill. Christine Graham has already mentioned that the Scottish Committee of Administrative Justice and Tribunals Council has a definition for these tribunals, and I wondered, Presiding Officer, since you weren't in the chamber at the time, if you'd like to hear it again.
Delighted.
Well, in that case, I will give you the definition. It's the body which resolves disputes between citizens and the state and between private parties by making binding decisions according to law. Does so by a process of adjudication, which is specialised, relatively informal and less adversarial as compared to the model of adjudication applied by the courts, and is independent of both the executive and the legislature and the parties appearing before it. Tribunals Scotland deal with 80,000 cases annually. Without them, those individuals would either lose an avenue for redress or would be forced to take their grievances to a court system that is already overstretched and sadly likely to be more so with court closures planned. In some instances, the tribunal is a forum for citizens to challenge decisions made by public bodies on their entitlement to benefits and services. Because of this, it is imperative that they are independent from government and that public organisations whose decisions they regulate. In other cases, they're a forum for the resolution of private disputes, for example, the Lands Tribunal, or issues arising from employment. In essence, tribunals offer a less formal and less costly dispute resolution mechanism as an alternative to the courts. However, as the Justice Committee heard from a wide range of witnesses, there is a need for reform of the complicated tribunal system which has developed on an ad hoc basis over the past decades. And the Justice Committee's Stage 1 report confirms that users and experts generally welcome this legislation as a step towards revising the administrative justice landscape. The legislation creates a first-tier tribunal for first-instance decisions, an upper tribunal to deal primarily with appeals, and a standard system of appointment, training and appeals, all of which is generally to be welcomed. There are nonetheless, as the Stage 1 report notes, some areas of concern which will require to be addressed as the bill progresses. These include the balancing act which this government must carry out between establishing a simplified uniform system and recognising that tribunals deal with very specialised areas of the law. This challenge was reflected in the evidence the Justice Committee received, for example, from the Lands Tribunal, a vocal critic of the bill, and the creation of a uniform system. In its written submission, it noted that to aim for common standards and procedures, including review and appeal, as a significant plank of policy, risks creation of a serious impediment to identifying the most efficient way of serving the different needs of individual users. Consequently, the Land Tribunal has argued that it should be placed in a separate pillar, a position that is supported by the Lord President, rather than occupying a division in the upper tribunal as the Scottish Government proposes. The difficulty with the Land Tribunal not being included in the new structure is the precedent it sets for this approach to apply to other tribunals equally specialist, which results then in a complex arrangement which would represent not a lot of change under the new system. So the challenge for the Scottish Government is to establish some standardisation without compromising the interests of users of the tribunal system. And I note the Minister explores this and recognises this with the requirement for flexibility. The Stage 1 report also highlights the legitimate concerns raised about judicialisation, or the so-called codification. In other words, ensuring that characteristics of tribunals, as distinct from courts, must be protected. This concern springs from, amongst other things, the provision in the bill that sheriffs, sheriff principals and part-time sheriffs will be eligible to act as judicial members of the first-tier tribunal by virtue of their judicial office alone. Whilst the Lord President is supportive of this proposal, an influx of judges and formal judges does risk turning tribunals from being informal, generally non-adversarial in character, to becoming courts in all but name. The Justice Committee's Stage 1 report therefore recommends that the Government seriously considers amending the bill to remove the automatic entitlement for appointments of judicial members. A further concern raised was that as judicial members may be appointed to the first-tier and upper-tier tribunals, the current gender inequality present in the wider judicial system would be replicated in the new tribunal structure. Furthermore, the bill makes provision for the newly established Scottish Civil Justice Council to propose procedural rules for the Scottish tribunals through a specialised tribunals committee. However, without additional resources, it will be years before the SCGC, which has to first rewrite a mountain of civil court rules, will be able to even consider tribunal rules. In the interim, the Government has proposed Scottish ministers make rules for Scottish tribunals. This interim rule-making arrangement poses serious constitutional issues as it will result in Scottish ministers writing the rules of administrative justice and significantly drafting the rules surrounding the newly created upper chamber. While this may already happen on a limited basis, it remains, as the Faculty of Advocates pointed out to the committee, undesirable on constitutional grounds. And as Jonathan Mitchell QC stated, Scottish ministers should have the same rights as other parties to proceedings before the tribunals to comment on proposed rules, but not to make them. Presiding Officer, Scottish ministers can be challenged in tribunals, and it is quite simply not appropriate that they have involvement in setting the rules. Clearly, an alternative must be found in the form of either the creation of a new independent interim body or the additional resources the SCGC would require to be in a position to carry out this role. Do you want me to wind up? In conclusion, Presiding Officer, can I just say these are all issues that will require to be addressed in the future. In the meantime, I confirm that the Scottish Conservatives will support the general principles of the bill this evening.
Many thanks. We now move to open debate. There is a modest amount of time in hand for interventions, only a modest amount. So I now call Colin Keir to be followed by John Pentland. 6 minutes or thereby, please.
Thank you, Deputy Presiding Officer. I'm not actually terribly sure if I'm delighted to be here doing this today. However, it's my last hurrah, I suppose, as a member of the Justice Committee. Actually, there is an element of déjà vu here. We have my memory of the last debate that we had in this chamber, and I remember our late colleague David McLetchie saying to me on the way out the chamber, Colin, with all that wittering on you did about the Citizens Advice Bureau, you gave me an extra 2 minutes to be able to wind up, and he still never managed it. Such was the agreement that was set around, and I have to say, thinking about that, I do miss David and his humour. I think many of us do. However, this debate is somewhat different. Since then, we've had a number of eminent people who have appeared in front of the Justice Committee, giving evidence, whether verbally or indeed in written form. And it actually has been quite fascinating. Elaine Elaine Murray, beg your pardon, did say earlier on that she did find it interesting, and there were aspects of it which were. Of course, the tribunals are designed, of course, to bring an easier, less expensive method of justice to society. And, of course, we hope that this carries on. It's really a setup which is not, in some cases, necessary to employ legal counsel. And, of course, as we all know, tribunals can get extremely complicated. And, of course, in most cases, a lawyer is usually required. And as we can see from the reports of some of the concerns that have been brought forward by a witness statement to the committee, this issue of what has been called judicialisation of the management and the procedure of the tribunals is worrying that it puts this accessibility more out of step and more closer to, is it courtification, I think was the word that was used earlier on. So obviously this is, as described by Ms Graham, I have here as well. So obviously it can't be wrong. But in broader terms, I do agree with the committee, who felt strongly that individual aspects of different tribunals, for example, the Additional Support Needs Tribunal and Mental Health Tribunal, shouldn't be lost within the new system. And with the moving of the mental health tribunals to an individual chamber of the first tier, as well as the proposals for the land tribunal, which has been pointed out by a number of speakers, can be incredibly complicated and perhaps, and has been mentioned, perhaps looking at the fact that it may be not so much a tribunal but a court, may be something that can be looked at. And I know that the complexities were described by the Minister. So any fears about losing the identities and methods of working gained over many years, identification, should be allayed. Another concern that I'm happy to see highlighted in the report is that of the children's hearings, which have just undergone a period of reform, and it would be an idea to keep that in mind if there's any further reforms required, and obviously try to avoid them going into the tribunal system as such. The power given to the ministers under the sections 26(2)(b), I believe it is, requiring regulations before Parliament subject to an affirmative procedure. I have a lot of notes here, but Margaret Mitchell has so kindly been through that with her concerns, and I won't... No, I refuse to do that again. Ms Graham, you sit there, you've had your shot. It will provide parliamentary protection anyway. The two-tier structure was quite interesting because over the period of months, we've always been complaining about people going into their own little silos and using all this terminology. And to actually see the way that it's all been mentioned with two-tier structures and how it's all going to work, and everybody's in agreement with it. But it does seem to be the right way. And once again, the description from the various colleagues on this has explained it better than perhaps I've got down here, and you're not going to hear because I'm hopefully going to run out of time fairly shortly. Much has been made of the suggestion by the current Lord President to name Lady Smith as the President of the Tribunals, and I do actually welcome the comments of clarification from the Minister that this is not an appointment but an assignment, And I think that's quite important, because that's the first time we've actually heard that, as far as I'm aware, that description. Because I did accept from the Lord President in committee that Lady Smith is more than qualified for the post, and I certainly would not argue against her credentials or suitability. It's just a little bit strange to see a name presented for a position before the legislation is actually in place to establish the post. So in terms of those who sit in tribunals, there were a number of comments, whether the term judge is used or not, and with regards to the person who presides over the tribunal. And there is the respect of keeping a clear distinction between a court and a tribunal. I understand that. I think it's quite important. And certainly in terms of symbolism, possibly it is a better idea to lose the title judge. There's been a number of quotes which I think about 3 or 4 people have mentioned so far, so I'm going to avoid that. All I would say is that in terms of this piece of legislation, which deals with a relatively small amount of work in terms of the size of the work as mentioned by Elaine Murray, at least, if I can be a little bit parochial, it's a case of, should we vote yes, next year we'll have plenty of scope to bring these tribunals into the system. Thank you.
Many thanks. Now call on John Pentland to be followed by Roderick Campbell.
Thank you, Presiding Officer. And Presiding Officer, sometimes you know it takes weeks to hear or see repetition, and I think we'll all agree. You know, we tend to say, "Oh no, not that again," but we're less than an hour into this debate, and believe me, you're going to hear much from me as what you've heard previously. So please enjoy and please try to keep awake. However, Presiding Officer, so far there has been a broad consensus in this bill and its principles and most of its measures it proposes. And this applies not only within the Parliament but among many of those who have submitted their views and given evidence. There were criticisms, but these had a sympathetic reception from the committee, which is keen to see them addressed as the bill progresses. The advantages of reforming tribunals were acknowledged through economies of scale and sharing of good practice and resources. But there was also a strong desire to retain the specialist support and knowledge embodied in the current arrangements. Basically, we don't want to throw out the baby with the bathwater. We want to keep the lay involvement, the less adversarial approach and the simpler, relatively informal, user-centred nature of existing tribunals. I hope that these principles will be made explicit within the bill, setting out the fundamental characteristics of tribunals. It was also felt to be important that the legislation was drafted in such a way that reserved tribunals could be brought into the structure at a later date. Now, the Law Society welcomes the proposed legislation, but has expressed their concern about the judicialisation of tribunals eroding their character. I agree that there is a danger that judicial members appointed under the provisions of the bill will not understand the informality and the centrality of the user within the tribunal process. The committee has asked the Scottish Government to consider what additional safeguards can be included to avoid this. In particular, there needs to be a direction within the bill that the President's discretion on appointment should be used to ensure that judicial members have the necessary expertise and understanding of the tribunal and its context. Now, while many submissions suggested ways to improve the bill to protect the characters of the tribunals, some were not convinced that this was possible for them. The Lands Tribunal for Scotland questioned the efficiency of that approach and whether it could adapt without creating significant problems to such a one-size-fits-all structure. It puts its case strongly, and the committee was persuaded to urge the Scottish Government to think again about its inclusion. The Valuation Appeals Committee was also concerned about the impact of imposing age limits, which would see over half their membership lost. The Mental Health Tribunal, in particular, also had unique characteristics, and there was support for it being retained in a chamber of its own. The worry, however, is that this would be a temporary measure by the Scottish Government, so there needs to be a long-term commitment to this arrangement for the Mental Health Tribunal. The other big area where reassurances are sought is the children's hearing system, which has already been subject to reform and which adds to the need for care when considering further change. And it's important that any regulations laid in this regard must be under the affirmative procedure to ensure that there is adequate consultation and parliamentary consideration of any proposals. There were also various concerns over cost, now well recognising that there is a potential to save money through the elimination of duplication and adoption of common administrative and other resources. There will also be cost involved in the transition. The long-term savings are one thing, but we should not risk success by trying to make the transition on the cheap. The issue of fees and charges is also important, as recent controversy over fees for the reserve employment tribunals has highlighted. Now, some of the devolved tribunals also have charges and fees, and therefore provision for them has been included in the bill. But it's important to ensure that this is not seen as opening the door to new changes being imposed where none previously existed, or as a platform for significant increases on existing charges. The committee proposes that any such charges should be subject to consultation with users and stakeholders. Now, regarding charges, there is another issue that needs to be addressed, namely the enforceability of their awards. Now, more than 50% of awards were not paid or not paid in full, and as part of our discussions, we should consider how to address this. Now, although I was not in the Justice Committee member at the time, I spoke in the debate on this matter last year. And as I said, I was in favour of reducing overlap and eliminating duplication, so long as it is a genuine overlap and duplication and elimination does not involve putting square pegs into round holes. We have now had the consultation and the committee has considered the proposed legislation. And my view is that this is the intention of the legislation, but the work remains to be done on the legislation to ensure that this is what it achieves in practice. So, Presiding Officer, in conclusion, you'll be glad to hear, I am content to support this at stage one, but with my fellow committee members, I will be looking for significant improvements to be tabled at stage two. Thank you.
Many thanks. Now call on Roderick Campbell to be followed by Alison McInnes.
Thank you, Presiding Officer. I welcome the opportunity to speak in this debate and refer members to my register of interest as a member of the Faculty of Advocates. As members will be aware, the UK Government has announced that reserved tribunals will not be devolved to the Scottish Parliament for the foreseeable future, something which is disappointing insomuch as it makes the aim of the bill to streamline and make more efficient the tribunal system in Scotland a little more difficult. But that's where we are at the present time. Notwithstanding that, of course, we do need to ensure that this legislation is fit to accommodate reserved tribunals in due course. But as Jonathan Mitchell of the Faculty of Advocates pointed out, without reserved tribunals, we're only dealing with about 2 to 3% of cases that come before tribunals in Scotland at the present time, and much less if the Lands Tribunal or indeed the Mental Health Tribunal were to be excluded. Much of the bill is technical, and to some, possibly even to the convener, who I see is now left, may appear very dull indeed. I accept, however, that repetition may be the order of the day here. I accept, however, there are a few matters also which I think merit some comment. Firstly, in relation to the Mental Health Tribunal forming a chamber of its own, given the volume of mental health work and the fact that 332 of the existing 460 tribunal members covered by the bill sit on mental health tribunals, that seems very sensible. Indeed, the proposals in relation to mental health were well received, with the exception of the possibility that the unique position of the Mental Health Tribunal as a separate chamber might be temporary. I note the Scottish Government's response on that issue, but I'm not sure that will fully allay those fears. So I certainly think a further engagement with the sector on this issue might be helpful. As to the presidency, should the president of the tribunals be a senator of the College of Justice, a judge or someone without such experience? I was not quite as enthusiastic as other members of the committee for the opening up of the field, as it were, to others with relevant experience. And if we are to move towards an integrated tribunal and court system, inevitably I think a judge would be in an advantageous position, whether appointed or assigned. As to the absence of a definition of tribunals from the bill, Citizens Advice Scotland and others have called for this to be defined in the bill and for a statement of overriding objectives, such as that in the Tribunals, Courts and Enforcement Act 2007, to be incorporated in this bill. Again, I note the Minister's comments on the definition issue, but I hope that her consideration of the overriding principles issues will give rise to an amendment at stage 2. I welcome also the statutory provisions placing a duty on key individuals, including MSPs, to ensure the independence of tribunals. As to procedural rules, particularly for the upper tribunal, I'm not sure I've got time, to be honest, but if it's brief, Mr. Stevenson.
Stuart Stevenson.
The member quite rightly identifies the duty that is placed on members of this Parliament not to prejudice the independence of members of the tribunal. Does he regret the fact that Schedule 5, Clause 1D of the Scotland Act means we do not have the power to create a similar enforcement to members of the UK Parliament representing Scottish constituencies who will continue to be able, should they so wish, and I don't suggest they would, to seek to influence tribunals, unlike the members of this Parliament?
You may have a little extra time.
Thank you, Presiding Officer. As always, the member makes a very good point. As to procedural rules, particularly for the upper tribunal, the evidence given was that the new Civil Justice Council could not deal with that in the short term. As Margaret Mitchell's already referred to, the Faculty of Advocates have expressed concerns of a constitutional nature that Scottish ministers should not be making rules. And even if, as the Minister said in evidence, Scottish ministers currently nominally write tribunal rules after consulting with relevant parties, this is, I believe, a practice that should be ended sooner rather than later. And I'd welcome further assurances from the Scottish Government in that respect on this issue. Accessibility, as even Ian Nisbet of Govan Lawset has said, tribunals are more accessible than going to court. Indeed, they're generally much cheaper, and our aim must be to preserve that accessibility. Turning to the Lands Tribunal, this remains one of the most controversial aspects of the bill. As Elaine Murray, has already mentioned, no, I think I need to make some progress, Mr. Stevenson. As Elaine Mitchell has already mentioned, Lord Gill said in evidence, the Lands Tribunal for Scotland is a court of law in all but name. I agree. John Wright of the Lands Tribunal, I think, made the point that the Lands Tribunal does not really fit in with the unified tribunal system proposed. And he advised that, in contrast to the Scottish position, in England and Wales, the Lands Tribunal was substantially an appeals body and therefore seemed to have a natural position in an upper tribunal system. In relation to expenses, John Wright outlined the variety of expenses orders that currently prevail in the Lands Tribunal, with different expenses rules for compulsory purchase, rating and indeed applications concerning title conditions. These orders do not fit easily into a tribunal system where expenses orders are a rarity. The prevailing ethos, at least in title conditions matters before the Lands Tribunal, is still that the winner gets his expenses. Indeed, as an aside, we as a committee in our review of title conditions expressed concerns about the implications of expenses orders, particularly as they impact on lowly homeowners up against wealthy developers. The truth, of course, is that particularly in respect of expenses, the Lands Tribunal more nearly resembles a court. As I've mentioned, the Lord President in evidence took the view that expenses orders in tribunal cases should be used sparingly and only in extreme cases. This does not really fit in with the Lands Tribunal. He did, of course, argue for the Lands Tribunal being in a separate pillar and with a separate administration. And whilst I accept the Minister's reservations on this and agree that if we were to make an exception for the Lands Tribunal, coherence may be lost, and indeed the remaining tribunals devoid of the Lands Tribunal might look somewhat sparse, and whilst I also note the Minister's comments on the appeals provision, nevertheless I think the Lands Tribunal does have very different characteristics from other tribunals. It has had the power to award expenses since the start, since 1949, and I therefore believe that continued dialogue between the Scottish Government, the Lands Tribunal and others, even at this late stage, might be appropriate. As to the question of a provision of permanent or salaried posts at the present time, I would agree with the Minister it's difficult to justify, but I am pleased that the bill will provide for the possibility of that in the future. Finally, if I can move on to the new interim committee to replace the Scottish Committee of the AGTC. This was, of course, not mentioned in our report. The interim committee is to be welcome, but I'm not sure what the long-term solution is. CAS and others are concerned about this issue, and they are proposing that somebody should have an overseeing function for administrative justice, such as the SCJC has in relation to civil justice. I think that's something that merits consideration. I'll be pleased to hear from the Minister on that. In conclusion, Presiding Officer, Jonathan Mitchell of the Faculty of Advocates described the bill as fundamentally a good bill, going the right way. I agree. Thank you, Presiding Officer.
And thank you. Now calling Alison McInnes to be followed by Nigel Dawn. 6 minutes, please.
Thank you very much, Presiding Officer. And let me begin by saying that despite having a few concerns that we believe need addressed at stage 2, the Liberal Democrats will support the bill in principle this afternoon. The tribunal system, as others have said, can and should be reformed to ensure that it's fit for purpose. Historically, it has developed in a piecemeal manner, and as a result, too often it seems disjointed and perplexing to legal professionals and lay people alike. The reforms also secure the independence of tribunals, something that is indeed overdue. Having a tribunal consider a case can be a defining, stressful, even traumatic time in someone's life, and therefore clear and consistent rules and procedures will help users, who often have no experience of the civil justice system and find it daunting, will allow them to overcome any anxiety and access proper redress. However, I want to take this opportunity to highlight some of our reservations, key areas which we need to examine further at stage 2 to ensure that the tribunal system will be sensitive, just and transparent. At the end of the bill process, we would want tribunals to be better placed to make decisions, to come to the right conclusions. The intentions are good, but we must be alert to any unintended consequences. We must be sure that it provides a greater depth of expertise amongst tribunal members and not a dilution thereof. That is why we must not allow the specialist knowledge and intrinsic character of a tribunal to be eroded to the extent that they are indistinguishable from courts, and others have touched on that this afternoon. They must continue to offer a comparatively faster resolution at a lower cost, in a less intimidating environment, be it a hospital or a community centre. The focus on the service user's needs, the comparatively informal and inquisitorial approach to cases, and the fact that lay experts sit alongside legal professionals all contribute to ensuring that tribunals have a distinctive role and a unique integrity. Concerns have been expressed that the bill could compromise these qualities. The committee has therefore suggested that the principles that underpin the tribunal system at present, those things which define it and set it apart from the courts, should be enshrined in the bill. And I know the Minister is instinctively cautious, but I welcome the fact that she's willing to consider this further. Concerns have been expressed, as others have said, about what has been described as a potential judicialisation of tribunals. The proposed merger of the service with the court service could lead to more judicial practices being rolled out in the former if it's simply absorbed. And members may be referred to as judges, something which we know would make many of them uncomfortable. The Law Society is concerned that the value of the ability of the first-tier tribunals to access the judiciary when making decisions will be undermined if judicial members do not have the necessary expertise. So we need to ensure that there are sufficient safeguards, such as the need to respect presidential discretion or consult the relevant chamber president when making judicial appointments. This is something that the committee in its report asked the government to consider, and again I hope that it's something that the Minister can reflect on further. Since the consultation on tribunal reform was launched, concerns have been repeatedly expressed about the future of the Mental Health Tribunal. Indeed, this subject attracted by far the most comments during the 12-week consultation period. It is a very different tribunal to those other devolved tribunals that are set to be transferred from 2015. The body has immense power over the lives of some of the most vulnerable people in our society. It has the power to detain patients in hospital or decide where they reside. It can rule on giving people treatment for mental illness against their will, and it can, as the Minister said, deprive people of their liberty. The extremely sensitive matters it considers means that it must be able to retain its existing, highly specialised expertise and experience. However, at present, the bill means that it could conceivably be part of a multi-jurisdictional chamber in the future. I listened carefully to the Minister's remarks this afternoon and found some reassurance in what she had to say. But should we be satisfied with the fact that it will be transferred into a chamber of its own in the first instance? The Scottish Government is seeking, after all, to establish an overarching framework, but there needs to be sufficient protections in place for this tribunal. I think it's therefore right to consider further whether mental health should be guaranteed its own chamber through primary legislation. Amending its status would then require a further act of Parliament, allowing for proper scrutiny and consideration rather than using regulations as proposed at the moment. Finally, vulnerable people, those in low incomes and hard-working families, typically cannot afford to incur any costs to access justice. And we must therefore guard against this becoming the norm rather than the exception in the tribunal system. I welcome the Minister's commitment to looking at whether this position can be strengthened at stage 2 to ensure that financial barriers to justice are not erected in the future. In conclusion, we will listen closely to what the Government has to say on these issues as the bill progresses through Parliament. I'm confident we can work on them constructively. Such an approach will, I hope, enable the bill to strike a proper balance between the need to make the system more consistent and transparent and the needs of service users, those often vulnerable people whose needs must remain our focus. Thank you.
Many thanks. I now call on Nigel Dawn to be followed by Graham Pearson. 6 minutes, please.
Thank you very much, Presiding Officer. I'd like to start by taking a step back in history, though I fear not as far as my good friend Mr Stevenson both has and probably will again. I take us back, Presiding Officer, to the report by Sir Oliver Franks in 1957, the result of the Critchell Down affair, as some may remember. And if I may quote briefly from there, since the war, which of course would have been the Second World War, the British electorate has chosen governments which accepted general responsibilities for the provision of extended social services and for the broad management of the economy. It has consequently become desirable to consider afresh the procedures by which the rights of individual citizens can be harmonised with the wider public interests. And at the bottom of the page, he goes on, but over most of the field of public administration, no formal procedure is provided for objecting or deciding on objections. For example, when foreign currency or a scarce commodity, such as petrol or coal, is rationed or allocated, signs of the times, there is no other body to which an individual applicant can appeal if the responsible administrative authority decides to allow him less than he'd requested. Of course, the aggrieved individual can always complain to the appropriate administrative authority, to his Member of Parliament, to a representative organisation, or to the press. But there is no formal procedure on which he can insist. And we can therefore note within the lifetime, I suspect, of most of us, that the world has moved on and that formal procedure, by and large, exists. And as the Minister has previously pointed out, each part of that procedure has been set up by its own Act of Parliament. And of course, it has come with its own set of rules and caveats and ideas at the time. However, Sir Oliver Franks made it quite clear in his next chapter that the aims of tribunals are actually pretty clear. And this is the point on which I'd like to dwell. Firstly, he points out that Parliament must have required good administration. That is actually what they're there for. And secondly, he noted that they must embody openness, fairness, and impartiality. So if I can step back as someone who was not on the committee and look at tribunals from the point of view of the individual who will appeal to them, I can suggest to Parliament that what that individual wants is actually pretty simple. The individual wants a tribunal that works. He or she wants to be treated with respect, and he or she definitely does not want to be overwhelmed by the other parties. And I have to concur with Christine Graham's earlier comments about education appeals, which I had to do in my time as a councillor, whereby there seemed to be a complete inequality between the two sides, the council being seriously overrepresented. The individual wants to be heard, of course, but we do need to be listened to. The individual wants the issues to be considered. And importantly, the individual wants all this to happen pretty soon. The individual also wants the correct law to be applied, the decision to be issued swiftly, and to be actioned accordingly. Now, all of that is pretty much straightforward stuff. I'm not expecting that to be remotely contentious. But if we remember that's what the tribunal should be delivering, then we will also, I suggest, note that the individual is by and large not concerned about titles. he or she really doesn't mind whether this person is a judge in description, whether or not that judge wants to be called judge is of no concern. Indeed, the whole process is of no concern, provided it's fair. And what the individual most certainly wants to avoid is costs, delays, uncertainty, and error. That, of course, is precisely what the system is supposed to provide. What do tribunal members want? What do those who actually take part in the process and bring the expertise to bear want? Well, they want a process that's going to provide them with all the evidence, so they do want the thing to be properly organised. They want the relevant parties to be there, so they certainly want this thing to appear to be a legal process that you turn up for. You don't just decide whether or not you're going to bother. They want somewhere appropriate to meet, of course, and they'd like the occasional cup of coffee. And when I say that they want somewhere appropriate to meet, there will be some who will need to do site visits. Those who are quite seriously engaged in land issues may actually need to go and look at the ditch which is being complained about. They also, and this is important, want a proper exposition of the law, which is why they do want a legally qualified representative at the very least. They also, I would suggest, want an opportunity to deliver their judgment fast. They want good leadership for the whole process, which is why I think I do concur with those who feel that the Lord President being ultimately in charge is an extremely good thing, and judicial oversight does seem to be right. And of course they want an organisation. And it's in that organisation which, of course, this piece of legislation is really involved. Each tribunal plainly can operate separately. They have. But they miss, in the process, economies of scale, cross-fertilisation, and they do all have their own way of doing things, and sometimes that won't be helpful. I think our experience of life, presiding officer, is that sensible rules of life are actually not complicated. I cannot but help feel that anybody who has actually ever convened a meeting in this place knows perfectly well that we have a set of rules of procedure. But actually, if you just get on with it in the normal, sensible way in which human beings do, and respect the chair, it's all more or less going to work. I note Margaret Mitchell's concerns about rules. I would seriously like to suggest that we can get overly taxed by rules. I think we have far too many, and we believe everything needs to be written down. The basic rules of administrative law, which I'm afraid do come in Latin because they're the Nemo Iudex rule and the Audi Autem Partem rule, are very, very simple definitions or descriptions of what you actually have to do things fairly. To finish up with a substantial rule book on how a tribunal is going to work seems to me to be something that needs to be justified and probably isn't. I note in winding up, therefore, presiding officer, that the Scottish Civil Justice Council, which has newly been produced, which some feel should be producing the rules for tribunals, and maybe it should. Well, I'm just wondering whether that Scottish Civil Justice Council should be producing the same set of rules for tribunals and all our courts, because I have a sneaking feeling that most of the rules are actually precisely the same, regardless of where you are in the system. Thank you.
Thank you. Now calling Graham Pearson to be followed by Sandra White. 6 minutes, please.
Thank you, Presiding Officer, for giving me the opportunity to contribute to this debate this afternoon. I hope it's not unkind to note that those in the public galleries have somewhat dwindled as the afternoon has gone on. And I would like to hope that that's because of their travel commitments rather than the nature of the business we conduct this afternoon. There's no doubt that on the face of it, the subject area of tribunals makes somewhat an unattractive subject matter for many in public life and indeed the general public. However, having been fortunate enough to hear evidence at Justice Committee earlier in the year when I was a member of that committee, it is quite evident that those matters overseen by tribunals on behalf of public life across Scotland conduct a valuable service which individual citizens weigh heavily and expect a great deal from. Earlier in the contributions, we heard from other members that some 80,000 cases are conducted across Scotland by various tribunals in pursuit of justice. The sheer volume of cases is indicative of the challenges that individual citizens face as they approach tribunals for adjudication. There's a David and Goliath aspect to what is an experience within a tribunal as an individual member of the public tries to understand what rights they're entitled to, how those rights have been decided, and whether or not a tribunal can explain on their behalf that either they are entitled to those rights or what reasons exist that would ensure that they could not access them. So to that extent, it's welcome that the Scottish Government, through this bill, has attempted to clarify the situation for tribunals across the country and to try and bring some order to the way in which they conduct their business. I should acknowledge at this stage that as a young student, I conducted a course in constitutional and administrative law as part of the degree I followed at Glasgow University. And in those years, I was in danger of being overcome by this sheer volume of information and the complex nature of tribunals. So it was sobering to realise that now, as a grey-headed member of this chamber, I was still in danger of being overwhelmed by the complexity and the sheer volume of information. So the appointment of the Lord President to oversee the implementation of the new bill is indeed to be welcomed. And I think that we would benefit from noting that a main aspect that leads from the appointment of the Lord President is that he will provide leadership and vision in taking forward the future for tribunals across this country and will represent the interests of tribunals here for Scottish ministers and the Parliament. Of course, I'm glad to.
Stevenson.
The member will recall from his studies the Courts Act of 1672, which shows quite clearly that this is not a new problem, and this is more or less the whole Act, that it be left and recommended that the judges of the court regulate the inferior offices thereof and order every other thing concerning the said court. There have been a few attempts in the past. It's interesting that even after hundreds of years, we're still dealing with the same subject.
Pearson.
Very much so, and I think that some of the debate within Justice Committee indicated that there were those within the tribunal environment who believed that through experience and time they had come to understood what was good for us all. But I think that each of us within the chamber realises that as much as we don't need too many rules, it's important that we do write some rules down that we can all acknowledge as delivering a clear outcome. The second responsibility for the Lord President is securing the efficient disposal of business. And with those 80,000 plus cases going through the courts or going through tribunals, it's quite evident that the efficient disposal of that business is important not only to the financial well-being of the government in supporting those tribunals, but also for the individual client who tries to get their cases through the tribunal process. But as has been mentioned earlier this afternoon, in deciding an efficient disposal, one would hope that fees will not become an attractive new way forward for generating the finance required to support tribunals, because as my colleague Ms McInnes has noted earlier, many of the people accessing tribunals have virtually no money. Many find themselves in dire circumstances and hence the need to approach tribunals, and any notion of a fee in those circumstances is actually a justice denied. And I'm heartened that there's some indication of a government understanding of these circumstances, and one hopes that at the end of the process we'll see that delivered in the final act. I think the issues that I would like to mention before closing are threesome. One, I think the definition of tribunal is well worth a review to see if that helps clarify things. Second, there was some comment in the debate at Justice Committee, and I haven't heard it referred to again, and having left that area may well have passed. But at one stage there was a concern that the Schedule 7 regulations, which indicated how members would be appointed, and the fact that at the age of 70 they would then be disbarred from continuing the appointment, may well cause a vacuum in the available membership of tribunals and the experiences necessary. And I hope that the government will take account of that. I'm conscious of time, and I think that at that point I'll end this contribution. Thanks very much.
Many thanks. Many thanks. Now call on Sandra White, to be followed by John Finney. 6 minutes, please.
Thank you, Presiding Officer. Last night I spoke in one of the second debates on women's issues, and I thought of a very popular song called, basically Sisters Are Doing It From Themselves, but I'm afraid I can't come up with a catchy title for this particular debate, so I think I'll leave it unless someone has a catchy title. Can I thank the Minister and fellow members for the very comprehensive contributions, so comprehensive in fact that I feel that most of the areas have been covered, but I will do my best to give some background information as to the, why we're looking at reform and some of the key aims of the bill. Now, the background to the Tribunals-Scotland-Bill was introduced on the 8th of May and is to create the framework for a new structure and organisation for devolved tribunals in Scotland. It will make a provision for the Act of the Scottish Parliament to establish the first tier tribunal for Scotland and the upper tribunal for Scotland also. Now, the policy memorandum explains that, and the bill notes that devolved tribunals have been established in an ad hoc fashion with no common leadership, appointments, practice and procedure or reviews and appeals. And this complex and fragmented system can lead to a narrowness of outlook and variation of standards and performances. And the bill creates a structure which will reduce overlap, elimination of duplication, ensure better deployment and allow for the wider sharing of available resources. And I think that's what a number of the members had mentioned earlier. And it is intended to create a system to improve the independence and the perception of independence of the devolved tribunals. The policy memorandum overview states that the bill will create a simple two-tier structure, a first-tier tribunal for the first instance decisions into which most tribunal jurisdictions will be transferred, and an upper tribunal where the primary function will be to dispose of appeals from the first tier 5. Under the leadership of the Lord President of the Court of Session, and certainly all members so far have welcomed that decision, as has the committee also. And the bill follows the Philip report and the 2011 Scottish Committee of the Administration, Justice and Tribunal Council's report. It follows on from them. Now, some of the issues I wanted to raise in regard to not just the background, but some of the issues that had been raised by the committee. And one of the issues that was raised by the committee was that basically we were looking at the judicial system, we were looking at judges being salaried. And I know that's been raised by Elaine Murray, Rod Campbell and a number of others. And it was something which the committee had said that perhaps we should look at. And I would like to quote from the committee minutes on this particular one. And one of the quotes from the committee minutes is that the bill makes no provision for the appointment of full-time salaried judges in any of the tribunals envisaged by the bill, and a number of concerns were therefore raised regarding this perceived gap in the legislation. And in reply from the Minister, basically said, I know the Minister will know exactly what this says, the Minister was not completely in favour of this suggestion, noting that it would be difficult to justify the need for full-time permanent judiciary, as you would be paying salaries to people who would not normally necessarily be there all the time. And I must say, whilst the committee has put forward the recommendations, I did raise during the committee process the knock-on effect to the financial memorandum in regards to that particular piece of legislation. And I would wonder if perhaps the Minister could further clarify or even go into more detail in this particular issue, because I really do think we have to know if the committee's recommendation of salaried judges for tribunals exactly what effect it would have in monetary terms and on any financial memorandum that would come through the actual bill. And I would like to, basically have a look at that also. Now, the committee, also made a number of recommendations, which included the government should resolve the delay in the production of rules for the upper tribunal as a matter of urgency. And I think a number of members have raised that also. And the Scottish Government should set out a definition of what a tribunal is within the bill in order to protect the character and nature of tribunals. And where a tribunal proposes introducing fees and expenses for the first time, consultation should be carried out with users and stakeholders of the tribunal. Now, I do concur with my fellow member John Pentland, who had raised this, the concerns that he had raised in regard to that, and I think Alice McInnes had also mentioned this particular issue, also in regards to fees being charged. And I note the comments from the Minister on these recommendations and others, and they are most welcome, but obviously if she feels she wants to get into further detail in her summing up, that would be most welcome also. As has been said previously, we're talking about an area where lots of people go to tribunals, they don't necessarily go to courts. And I know it's been a lot said, and I think Nigel Dawn mentioned the fact that, it's a legal system, and people who sit on the tribunals perceive it to be a type of judiciary system. And I know the recommendations about people being called judges or judiciary. But the one thing I do think will happen with this bill, as we go through the further stages, is it will make it easier for people, ordinary members of the public, to understand the tribunal system. Because I think that's what we're trying to set up here, the lack of duplication and a better understanding for ordinary members of the public who go to tribunals to find out exactly what it is all about, and a better service for them also. Thank you, Presiding Officer.
Thank you. I now call on John Finney to be followed by Willie Coffey. 6 minutes, please.
Thank you, Presiding Officer. The Justice Committee described the bill as, and I quote here, a welcome development in revising the administrative justice landscape. And we've certainly heard the varied tribunals that are covered in that landscape and the number of cases, that 80,000 odd, that are dealt with. And the fact that that's a very small percentage of the overall cases, 2-3% of those, with the rest being covered by reserved tribunals. I'm grateful for the witnesses, for the evidence they gave, and indeed for the organisations that provided briefings. I'd like to allude to the Citizens Advice Bureau briefing, where they say the facet that, with regard to tribunals, is the facet of the justice system people are most likely to have access. Well, if they're going to access it, it must be accessible. And I concur with the view of the Citizens Advice Bureau and indeed others that the purpose should be on the face of the bill. And if I just read some of the principles that they suggest, place the needs of the user at the core of tribunals, helping to ensure that both practice and procedure is accessible. And in the policy memorandum with regard to islands and rural communities, it says the bill has no deferential impact on island and rural communities. Now, that will be the case, but I hope that technology can be embraced and that can be done in conjunction with court services in cooperation with the public service to ensure accessibility. Fair, expeditious and just. Now, that will require adequate resourcing, and like many here, I certainly don't favour the resourcing coming by way of fees, and that will affect the access people will have. To provide a safeguard that the spirit of tribunals and the distinctive nature of individual tribunals will be maintained. Well, that's been covered by many speakers, and I think we do know that there are a unique range of not only subjects but manners in which these subjects are dealt with. Provide a framework for defining principles to frame the development of new tribunals. And I think, again, we've heard from the Minister that there's a feeling that it is adequately loose, if I can use that term, to absorb future community tribunals. Help to mitigate the lack of detail about procedure on the face of the bill by guaranteeing a minimum standard to which all Scottish tribunals should operate. And I don't think these are at all unreasonable, and I hope that these can be looked at. Now, much has been made of the special case the Land Tribunal believe they are, and I certainly don't view them in that view. They said that they didn't really fit in with the scheme. Well, the Minister in a written response told us that all the tribunals are unique, and I certainly wouldn't place one above any of them. The mental health has been referred to, And the fact that someone can be deprived of their liberty, the challenges associated with additional support needs, I think they're all important and all should be treated in a similar way. And turning now to the postponement of the inclusion of reserve tribunals, the committee certainly formed the view that we would welcome the inclusion of the other tribunals, and the report that was submitted said this is something that's clearly not entirely in the hands of the Scottish Government. Well, I don't think it's in the hands of the Scottish Government at all. The report did go on to urge the Scottish Government to work with the UK Government to ensure early progress, and we have heard that these discussions are ongoing, and to examine closely whether the bill as drafted will create any barriers to the future inclusion of reserve tribunals, and not that we identified any of them. Certainly welcome the significant role that they play in Civic Scotland and the oversight of the Lord President. With regard to the appointment and my early intervention with the Minister on that, this is not about an individual at all, far from it. We're told in the report back from the Scottish Government, the position, I quote here, the position is not a standalone appointment, it's an assignment by the Lord President. The President of the Scottish Tribunals has to be a senior person from within the Lord President's judicial complement, as they will have responsibility for managing the upper tribunal, which will be made up of senators, sheriff principals and sheriffs as well as chamber. Now, there's a debate about appointment rather versus assignment. How do you become assigned? Rod Campbell talked about opening up the field. How do you open up the field if you don't know the boundaries of that field? I don't think it's at all unreasonable. In fact, in many respects, the answer gives us an outline to the job description. Public appointments should have a post and person specification. As I say, it's not about personalities. It is about public confidence, and certainly in judicial and senior circles in Scotland, things not being seen as some sort of exclusive club. So the committee did commend the idea of extending the pool of eligible candidates. Welcome the Minister's response about the use of the term judge. I think we want to see the tribunals act independently and make their own decisions. But as we heard, implying wigs and gowns may be intimidating and off-putting tribunal users, and I think that certainly is the case. It should be a forum for the layperson, and that certainly isn't my experience of the Employment Tribunal, and I would go along with a lot of what Elaine Murray said about the changes that have taken place there, and to that I would add increased qualifying periods of 1 to 2 years, the fees, reduction in compensation, and judges sitting alone. And if we come to inherit the Employment Tribunal, it's certainly a different beast from recent years that we're going to, and I think there would be an opportunity for this chamber to reinstate some of the fairness and opportunity with control of employment law. The issue of specialisms has been mentioned on a number of occasions, Presiding Officer, and there's another human resource term that should apply, and that is succession planning. If we go to the explanatory note, we see that the Mental Health Tribunal for Scotland currently has 332 members. The Scottish Charity Appeals Tribunals has 19. Further on, in Table 3, a projection of numbers of members approaching 70 and the number of resignations would be anticipated. I certainly don't favour age discrimination. I think people should hold a job on the basis of competence so to do. One of the ways to deal with this is not to invest specialism in individuals, but to ensure that knowledge is widely spread by having succession planning systems. I'll conclude now, Presiding Officer, by once again mentioning something the Citizens Advice Bureau said that I think we could all go along with, and that is placing the needs of the user at the centre of this. I'm certainly very happy to support the bill at stage 1. Thank you.
Many thanks. I now call Willie Coffey to be followed by Lewis MacDonald.
Thanks very much, Presiding Officer. And before I make my contribution to this fascinating debate, I can't help thinking that on occasions gone past in this chamber, we would surely by now have been treated to some mirth and devilment from our former colleague David McLetchie, who was also mentioned by my colleague Colin Keir. David, I'm certain, would have enjoyed the proposition that tribunals were a place where justice could be determined without the necessity for lawyers to make an appearance. And similarly, from our own Brian Adam, we would have listened, I think, in reverential silence to the wit and wisdom of an experienced voice in the Parliament, guiding us through a process like this with a steady hand and some gentle reasoning. Two great members of the Scottish Parliament sadly missed. Presiding Officer, in reviewing the papers for the debate, I thought a good place to start might be to ask a fairly basic but fundamental question, and that was, what exactly is a tribunal? I knew about tribunals from past experience, of course, but had naively expected that a bill on tribunals making its way through the Parliament might actually define what tribunals were or would be. Were we about to legislate in something we weren't going to define? Nothing is ever quite that simple, of course, and the evidence at committee about the distinct nature of tribunals appeared to suggest that attempts at defining what they were could lead to a loss of uniqueness. Thankfully, however, the committee didn't buy that particular argument and has asked the Scottish Government to set a definition out on the face of the bill. Now, the Scottish Government appears in their response to be happy to define the principles for tribunals along the lines of those included in the Tribunals Act, as mentioned by the Minister in her opening speech. I think there may have been some misunderstanding about the proposals and the purpose of introducing the bill. As I understand it, creating a unified tribunal structure offers us the best of both worlds, a system where the public can expect consistent processes and procedures with consistency and quality of expertise being available, but at the same time ensuring that specialisms of some tribunals like the Mental Health Tribunal and the Additional Support Needs Tribunal remain in place. Yes, of course, it's a careful balance, but the committee seems confident that that can be achieved. From what I have read, the current tribunal system is mainly ad hoc, with little common ground in leadership, appointments, procedures, reviews and appeals, and this bill aims to address those concerns and ultimately, by doing so, should deliver a better system for the public. I'd like now to pick out a few elements for the bill that I think are important and merit further mention in the debate today. On tribunal independence, it should be welcomed that the bill proposes a statutory obligation to ensure that tribunal hearings are heard by people with no links to the body whom they may be challenging. A seemingly obvious requirement, but one which was not always guaranteed. For example, there have been occasions where appeals and educational placing requests may have been heard by people appointed by the Education Authority itself. And this guarantee will surely provide greater comfort to appellants. I note the provision relating to appeals and reviews also generated some differing views in the committee, and for me it was less than clear and probably still needs a little bit of work done. I note that the first tier and upper tribunals may review their own decisions, and appeals may be lodged from one level upwards to the other, and then also, of course, on to the Court of Session. But Jonathan Mitchell QC, who has been mentioned by one or two of the members today, warned against making the grounds for appeal overly restrictive, and that a person may win a first-tier appeal, have it overturned by the upper tier, and find themselves unable to challenge this at the Court of Session because of the restrictions imposed. I would hope that we end up with an appeal and review process that does not diminish the appellant's right to challenge perceived injustice simply because of the imposition of strict rules in this regard. From what I could see, the committee probably took the reasonable view of asking that this aspect of the bill be kept under some review. The submission from the Lands Tribunal, again mentioned by members in the Chamber today, made a case that it should be excluded from the provisions of the bill in that it was already operating as a court and doing so quite successfully for many years. However, I note the comments from the Minister on this, and that this would probably defeat the overall aims of the bill, creating anomalies at the outset. It seems to me that the Lands Tribunal, which is highly regarded, would sit comfortably within any new system that had improved systems and processes at its core. The Scottish Government response to this would appear to reflect that and intends to transfer the Lands Tribunal to the upper tier. On the Mental Health Tribunal, a very strong case was made due to the expert nature of much of its considerations to retain it within its own chamber. And my understanding, again from the Scottish Government response, is that this will indeed remain the case. Lastly, on the matter of children's hearings, there was some concern from the Scottish Children's Reporter and from our Commissioner for Children and Young People about a possible transfer to the tribunals, particularly since it has only recently been reformed. Although it has to be said they were not opposed in principle to this. But there do appear to be sufficient safeguards here requiring Scottish ministers to undertake the necessary consultation in advance of laying any further regulations before the Parliament. In summary, Presiding Officer, Scotland's tribunal system offers our people access to justice in an informal setting, safeguarding the rights of ordinary people who feel they have suffered an injustice. It's right that the Scottish Government seeks to modernise the system, make it simpler, consistent and easier to access. It's right, too, that we carefully establish the ground rules for reviews and appeals, but always with the rights of the public in mind, so that justice is served first and always. The new system will need time to settle in and will clearly be in a position to absorb in due course those tribunals that are currently reserved by the UK. And with that, Presiding Officer, I'm happy to support the Government motion in front of us today. Thank you.
Many thanks. I now call Lewis MacDonald to be followed by Gordon MacDonald.
Thank you very much. And it is, of course, as Christine Graham nearly said, a pleasure to join a debate on the stage one of a Justice Bill on a Thursday afternoon. Willie Coffey and Colin Keir both made mention of much-missed members of this Parliament no longer with us, and of course the late great Donald Dewar, when he advocated devolution, always listed as one of the causes for that change that at Westminster there simply was not the time or the opportunity to bring up to date Scots law and Scottish legal processes in the way that all of us would have wanted. And that, I think, is something that is addressed. And now, indeed, finding parliamentary time to debate these matters is no longer a challenge. The real challenge is not, as some members have suggested, to fill in the time we have found. It is actually to get the process of reform right when we have the time to do it. And as has been said, tribunals deal with more cases in Scotland each year than the criminal and civil courts put together. And what is most striking about the Stage 1 report from the Justice Committee is its view that this bill still has some way to go to get it right. It is agreed that tribunals will be more accessible and better understood if they operate within a common framework, and the general principles of the bill command broad support. Of course, the Conservative-led government at Westminster might argue that it is also enacting the same general principles in its reform of UK-wide tribunals, but some of its reforms do not command broad support. Employment tribunals, for example, appear to be under attack for political reasons. In Scotland and across the UK, working people are less likely to seek redress against unfair treatment at work because of the introduction of fees. The statistics, albeit for only the first few months, suggest that there is already a fall in the number of cases brought, in particular those brought by individual employees rather than those brought by or on behalf of several workers through their trade unions. This matters for two reasons which are relevant to this bill. First, the introduction of fees in employment tribunals is arguably a matter of procedure rather than of statute, and procedures in Scotland, even for UK tribunals, are defined in terms of the law of Scotland. There might therefore be implications for devolved areas, and it would be interesting to hear the Minister's view on whether more might have been done to debate this issue here before we all gave legislative consent to the relevant Westminster legislation. Secondly, this bill creates a mechanism to allow Scottish ministers to introduce fees and charges for use of tribunals in devolved areas, including tribunals where, as John Penton said, no such fees apply at present. And that provision has itself rightly caused concern to members of the Justice Committee. As the Faculty of Advocates commented, imposing fees on users of, for example, the Mental Health Tribunal would be unthinkable, yet it would be possible under the bill as it currently stands. The intention to require an affirmative resolution before fees could be introduced is welcomed, but the committee is right to call for wider consultation to be required before any such resolution was passed. And it is hard to see why an existing power for some tribunals to charge fees should require provision for other tribunals to be given the same powers unless it is in pursuit of uniformity for its own sake. The parallel reforms of UK tribunals have brought in fees in a way that tilts the balance of the tribunal system against users, and this bill must be proofed against that outcome. The fact that there is a parallel process has also itself apparently caused some concern. One of the distinctive features of the Scottish justice system is that there are areas where justice is done without too much reliance on courtrooms, on lawyers and on formal proceedings. Children's hearings are the best example of that, but many other tribunals work because they retain a user-friendly informality that we should work hard to protect. The committee has raised a number of concerns about the risks of turning tribunals into something more like a formal court of law. The merging of the UK tribunal service with HM courts surely runs that risk of judicialisation of those tribunals, and Scottish ministers, I'm sure, will think long and hard about how to maintain the distinctiveness of Scottish tribunals, if indeed they follow the UK government's model of administrative rationalisation, as their consultation earlier this year has proposed. Children's hearings themselves are also an area where the Justice Committee sounds a note of caution. In the last Parliament, ministers came perilously close to damaging what was most Scottish and most valuable about the Scottish approach to young offenders: children's hearings centred on the child rather than youth courts focused on proving guilt. Happily, ministers came back from that particular brink, but there has to be a real concern about ministers in future pushing the children's hearings into a tribunal service straitjacket, which would potentially again put their distinctive character at risk. And likewise, as a number of members have said, the distinctive character of the Mental Health Tribunal for Scotland needs to be protected in future. The decision to treat it as a standalone chamber is welcome, but that commitment to protect its distinctive role needs to be given greater certainty in the medium to longer term. And at the opposite end of the spectrum is the Lands Tribunal for Scotland. As Elaine Murray reminded us, the Lord President describes it as a court of law in all but name, something that isn't broken and doesn't need fixing. The Lands Tribunal itself is against being pulled into the new system, and it appears that nobody is particularly keen to do that except ministers. And clearly, we should not have that happen simply on the basis that it's standing alone as a separate pillar prevents everything from being the same. Because clearly everything should not be the same. By all means, create a common framework where that is appropriate, but the urge to make all our tribunals fit precisely into a single template should surely be resisted. It is how things work in practice that is the important question, and I hope ministers will listen to the concerns raised and amend this bill, as has been said, to make it fit for purpose.
Thank you very much. And I now call Gordon MacDonald, to be followed by Stuart Stevenson.
Thank you, Presiding Officer. As one of the last speakers in the open debate, especially someone who has not had the benefit of listening to the evidence gathered in committee, I apologise in advance for any repetition that you're about to hear. And in answer to Sandra White's earlier search for a song title, may I suggest the average White band's Let's Go Round Again. Presiding Officer, I think it's important to highlight why this bill is necessary. The policy memorandum for the bill notes that devolved tribunals have been established in an ad hoc fashion with no common leadership, appointments, practice and procedures or reviews and appeals. This complex and fragmented system can lead to a narrowness of outlook and variation of standards and performances. The bill creates a structure that will reduce overlap, eliminate duplication, ensure better deployment and allow for the wider sharing of available resources. It is intended to create a system to improve the independence and perception of independence of the devolved tribunals. The policy memorandum overview highlights that the bill will create a simple two-tier structure, a first-tier tribunal for first instance decisions and an upper tribunal where the primary function will be to dispose of appeals from the first tier. The Scottish Committee of the Administrative Justice and Tribunals Council, in its 2011 report, Tribunal Reform in Scotland, A Vision for the Future, defines a tribunal as, and I know Christine Graham and Margaret Mitchell has already given you this definition, but I think it's worthy of repeating. A body which resolves disputes between citizens and state and between private parties by making binding decisions according to law, does so by a process of adjudication which is specialised, relatively informal and less adversarial as compared to the model of adjudication applied by the courts, and is independent of both the executive and the legislature of the parties appearing before it. There are 18 devolved tribunals, all of whom have different powers and processes dealing with a range of different subject matters, from the compulsory treatment orders under the Mental Health Act to adjudication on disputed parking tickets. The proposed changes including the Tribunals-Bill, only applies to the 18 devolved tribunals and not the 24 that operate on a GB basis, covering a whole range of subjects from criminal injuries to social security and child support appeals. The aim of the bill is to change the current tribunal system in order that it is less complicated, more independent and more user-friendly. The bill will create a new structure for devolved tribunals, a new leadership structure under the Lord President, a new Office of President of Scottish Tribunals, a new process for appointing tribunal judiciary and a new process for making rules. What it will mean for the user is it will give them access to a more coherent tribunal structure. Appeals will be taken out of the court system. There will be a common procedure for appointments, complaints and disciplinary processes, and importantly, despite the changes, give access to the same specialist members, venues and staff. The bill has generally been welcomed as an improvement on the existing system. Witnesses noted that the benefits of the new system would include providing the opportunity for generic training, dealing with questions about the conduct of tribunal judges, as well as sharing the expertise that has been gained from the tribunals. The bill would also give coherence to what already exists. Citizens Advice Scotland, who have a wealth of experience in supporting and representing clients, having represented 5,500 clients in civil court and tribunal cases in 2011-12, believe that the proposed structure is an improvement on the existing system. Govan Law Centre noted that an existing benefit of tribunals is that they are more accessible than going to court. They concluded that the primary benefit of the new structure, from a user's point of view, was that those advantages will be extended to the first tier of appeals. The Scottish Independent Advocacy Alliance, whose members have supported many individuals in mental health tribunals, welcome the bill's proposals which aim to provide consistency in practice and procedure. If we are to provide that level of consistency in practice and procedure, then we have to examine the position of all tribunals operating in Scotland. The Justice Committee's recommendations recognises this, and their second recommendation states, "We concur with the position that, for this process to be most effective, reserved tribunals in Scotland should be included within the new structure." We note that this issue is not entirely in the hands of the Scottish Government, but we urge it to work with the UK Government to ensure that early progress can be made on this matter. In doing so, we call on the Scottish Government to examine closely whether the bill as drafted will create any barriers to the future inclusion of reserved tribunals. In ensuring that all tribunals operating in Scotland abide by the same standards, we also have to consider accessibility. Sir Andrew Leggett, in assessing the position south of the border, stated, "It should never be forgotten that tribunals exist for users and not the other way around. No matter how good tribunals may be, they do not fulfil their function unless they are accessible by the people who want to use them." The policy memorandum states that the intention of the bill is to facilitate improvements in the quality of services offered to users of tribunals. This need was also identified by a number of witnesses. The Additional Support Needs Tribunal for Scotland noted that our concern must be to the tribunal user, to whom the primary benefit must apply and who must be at the heart of the system. Presiding Officer, this bill is the right way forward in bringing tribunals into the 21st century and providing the accessible, straightforward, independent and user-friendly service that we want for our country.
Thank you very much. And I finally call Stuart Stevenson, just over 6 minutes.
Thank you very much, Presiding Officer. Some of us have forgotten that political debates are not over when everything has been said, but only when everyone has said it, most recently Gordon MacDonald. However, I hope to avoid that particular trap. It's perhaps worth going way back to where tribunals actually came from. They came from the Tribuni Plebis, which followed a battle in 494 BC, when the legionnaires refused to go out and fight for Rome. And to buy them off, the plebs were given the right to elect plebeian tribunes. And the tribunes were made sacrosanct while they held in office. The tribune was the principal and guarantor of the civil liberties of the Roman citizens against arbitrary state power. And I think that's a pretty good basis for what tribunals are. Willie Coffey talked about the rights of the public, so zooming forward a couple of thousands of years to the College of Justice Act 1532, which reads, "And there are persons to be sworn to minister justice equally to all persons in such causes as shall happen to come before them, with such other rules and statutes as shall please the king." OK, up to that point, as shall please the king. But that's the way the Constitution worked in those days. So a lot of what we're discussing today, it just ain't new. We've looked at it many times over the hundreds of years. Of course, in the 1600s, we had a considerable debate about the divine right of kings or the power of the people. And in an attempt to reassert the divine right of kings, the Crown Appointments Act of 1661 declared that it is an inherent privilege of the Crown to have sole choice and appointment of the officers of Parliament, Privy Councillors, and the nominations of the Lords of the Sessions. Fortunately, we've moved on from that. The Spice Brief... I'm going to try and fill my six...
Christine Graham.
Just because I was not aware, I think I may blunder here, but the divine right of kings pertained to the Scottish kings, that was an English concept, and that Scottish kings were there by leave of the Scottish people from the Declaration of Arbroath. I see Lucy MacDonald's nodding, so I have an ally.
Stuart Stevenson.
Well, I'll simply remind the member that was the 6th Act of 1661 by the Estates of the Scots Parliament. So I think things are probably not quite so clear-cut as the member suggests. They certainly tried. Did they succeed? A debate for another day. Spice's briefing draws our attention to concerns about whether tribunals' lack of independence from government, perceived or otherwise, is in contradiction of Article 6 of the European Convention on Human Rights. And I think the legislation that we are looking at today and that we'll be looking at in time to come is going to be an opportunity to set pretty rigid statement that they are independent. Turning to some of the things that are actually in the bill that's before us, Eddie made reference on the back of Rod Campbell's comments about the upholding of independence of the members of Scottish tribunals and the duty that's placed on members of the Scottish Parliament. This is quite an interesting one because the bill doesn't directly prescribe what happens if a member or members collectively of the Scottish Parliament fail to uphold that. I suspect that the Code of Conduct of the Parliament at 3.13 may cover it, where members should uphold the law. But I suspect there is ambiguity perhaps there that committee and Parliament may continue to look at. Now, of course, the whole issue of tribunals is not one that we've not failed to look at before. Reference was made by Willie Coffey to David McCletchie. Well, there was a debate that David McCletchie led in March 2004, which was on the Fraser Inquiry. And one of the issues the Fraser Inquiry had was that it was unable to get access to the powers that would have been available had it been a Westminster inquiry under the Tribunals of Inquiry Evidence Act, whereby they could have been given the power to command witnesses to appear before them and to bring the necessary evidence. So we've kind of been there. And I think we've perhaps overlooked that there are some significant potential effects in our not having all the powers that we might seek. When I, as a minister, took through the Long Leases Act through Parliament, in the Stage 1 debate on that, I had to refer to tribunals as well. Because tribunals, of course, are an important part of judging the value of land, and that was central to part of the debate on that particular subject. It's perhaps as the time approaches where should wind up, I'll just say a little bit about mental health tribunals. They are very special. They're different in the very distinct sense that they're about the deprivation of liberty of a citizen, which is quite unusual for a tribunal, albeit it is in the interests of the citizen that that be undertaken. So I certainly would want to see that we do protect the right of the citizen. This is, for me, an interesting speech because it's my 500th that I've made here, so it's a special round number, and it feels like many more the convener is saying. But let me just close, convener, by quoting from the College of Justice Act of 1532, which says that we intend to institute a college of cunning and wise men. That might be the kind of people we want involved in our tribunals, and that the persons be sworn to minister justice to all persons in such causes as shall happen to come before them. And let's extend it to women in this modern age as well, as the Minister has urged me to do. Presiding Officer.
Many thanks. That brings us to the closing speeches. And I call on Annabel Goldie, 7 minutes.
Thank you, Deputy Presiding Officer. Can I welcome the opportunity to speak today at this Stage 1 debate on the Tribunals Reform-Scotland-Bill. I'm not in the Justice Committee. I have to tell you that undreamt of vistas without limit of horizon have opened up for me this afternoon. Who would have imagined that reform of tribunals could reveal such glittering facets as judicialisation and courtification? But I have to say, Deputy Presiding Officer, one feature has distressed me, indeed alarmed me. While the rest of us have been sustained throughout the afternoon with the presence of colleagues, the Minister for lengthy chunks has been on her own. And quite honestly, in the 21st century, in a debate like this, that is not humane. And I think the Scottish Government should address it without delay. Now, I accept the topic of reform of our tribunal system may not set the policies racing, but it is, as contributions today have acknowledged, an important topic, and reform is overdue. The tribunal system, as we know it, grew up on an ad hoc basis during the 20th century as governments acquired more and more power over citizens' daily lives. And an important landmark was the 1957 Franks report to which Nigel Donne referred. And it followed the Critchlow Down affair, in which land acquired during the Second World War was not returned to the previous owner, but was instead handed over to the Ministry of Agriculture and leased out. So land grab is nothing new. And following this scandal, the Franks report moved tribunals from an executive and administrative model towards a judicial footing, based on the 3 principles of openness, fairness and impartiality. I think that was an important change. And that judicial footing can be observed without either judge overload or, to use this extraordinary word, courtification. That sounds more to me like a mandatory term for wooing. So I hope the Minister will let me know how she gets on. Now, in Scotland, there is a clear division between tribunals which deal with devolved matters and are therefore under the responsibility of the Scottish Government and those which are reserved. However, users of a tribunal are unlikely to be concerned about or indeed aware of, or for that matter care, whether a tribunal is devolved or reserved. What we have to come up with is a system which is as efficient as it can be, which is fair, but which above all meets the needs of the users. Indeed, the Minister specifically referred to that. So I welcome the Scottish Government's commitment to continue to working with the UK Government and coming up with a satisfactory solution for the reserved tribunals, which are more numerous and deal with far more cases than the devolved tribunals. The complexity of the system has been touched upon. It's self-evident. The Minister has found a friend. I am much comforted, much comforted. The complexity of the system has been commented on during the debate, and indeed the Phillips report in 2008 specifically referred to that complexity and fragmentation, and also expressed concern that the system didn't meet the key principles of independence and coherence. I think we all acknowledge that complexity is neither in the best interest of the users of tribunals, nor does duplication of resource in whatever form that occurs represent value for money. And while the Scottish Government has taken some limited steps to simplify the system, most notably by bringing some of the devolved tribunals under the administration of the Scottish Tribunal Service, progress has been slow. And I just would observe that the UK equivalent to this bill was actually passed 6 years ago. And as Roderick Campbell observed, the legislation before us does represent movement, but it will still only apply to around a tiny 2% of tribunal cases north of the border. I think there is a risk that we may create different systems for tribunals in Scotland, compounding the complexity which surrounds them. That would be very unfortunate. Currently, only some tribunals are supported by the Scottish Tribunal Service, and this bill will establish a separate structure for some devolved tribunals, will leave untouched other devolved tribunals, as well as all the reserved tribunals. But let me just comment on a few points raised in the Stage 1 report. As Margaret Mitchell said, the Lands Tribunal for Scotland has expressed concern. A number of speakers have commented on that, and I think and expect the Minister will comment on that, but it does raise the wider point that the challenge for the Scottish Government is coming up with a system which preserves the specialist qualities that the Lands Tribunal requires without complicating a structure which is meant to try and simplify things. Now, I would also reiterate the points made about the importance of protecting our tribunal's unique and distinct approach to civil justice. There is no doubt that the informality and less adversarial nature of our tribunals compared to the courts is a strength. But there is, I think, a legitimate concern that with the Lord President in charge, a senior judge appointed as President of the tribunals and the expansion of judicial members, care must be taken to avoid judge overload. I have to say that I do hear alarm bells ringing with the proposal that until the newly created Scottish Civil Justice Council is in a position to take over, ministers will make procedural rules. Now, quite simply, in my opinion, ministers, who are of course sometimes subject to tribunal proceedings, should not be making the rules, no matter how much independent or expert advice they take. I think the rules should be made on an interim basis, either by the new Scottish Civil Justice Council with additional resource or by some other interim body. Other speakers have commented on independence. I think independence is critical to tribunals, and I feel the bill could do more to promote that, something I think the Lord President shared with the Justice Committee. Indeed, I understand he suggested the inclusion of a similar provision in the bill as that in the Judiciary and Courts Scotland Act of 2008. Maybe that's something the Scottish Government will look at. I think it is interesting, the new structure, the position of President of Tribunals appointed by the Lord President. I've noticed the restriction that the bill does limit the pool of candidates to Senators of the College of Justice. I have no quarrel with the Senators of the College of Justice, but that pool is deep rather than wide, and I think that does need to be broadened out, that the system would benefit from a wider scope of qualified and experienced personnel. And finally, Deputy Presiding Officer, the Stage 1 report notes that much of the detail of the new structure is not contained in the bill we are discussing. One or two speakers have referred to this. And I am slightly concerned about that. I think that hampers scrutiny. And while I accept the legislation seeks to provide a framework for the new structure and needs to be flexible, you know, the amount of detail that's going to be left to delegated legislation is disquieting. And I hope the Government will take forward some of the comments of the Delegated Powers Committee. I know the Justice Committee will closely scrutinise the forthcoming secondary legislation, but it already has an enormous workload, and I think the committee would have preferred that Parliament had been given more specific information about the detail of the proposed new structure. So perhaps the Minister could address that. In conclusion, Deputy Presiding Officer, the Government, I believe, is looking at the merger of the Scottish Tribunal Service with the Scottish Court Service. But has the Government looked at related numbers, such as the sheer number of tribunals and the concerns which have been expressed over the independence of some of these? Thank you.
Thank you very much. And now call Elaine Murray, 8 minutes.
Thank you, Presiding Officer. And can I first of all thank members for their valiant efforts to keep this debate going. I did have fears that there would be huge amounts of time left for the closing speakers, and we would have to try and fill all those up. So I'm very grateful to all members for their efforts in making sure that didn't happen. I did at one point see Mr Q licking his paws with a rather resigned air, which may have reflected the feelings of members in the chamber. We did have some points of excitement. I have to say it's Stuart Stevenson implying that the convener could remember the Courts Act of 1672, I think it was uncharacteristically ungentlemanly, I felt. At least he didn't suggest any of us could remember 494 BC, or indeed, in fact, when he came to use the term plebs, I began to get a little bit worried on his behalf. But Nigel John Dunn also, I think, may have caused a little bit of offence by suggesting that members of the Chamber could remember the Oliver Franks report of 1957. That may be true of some, but I'm sure some of our colleagues probably would be rather offended by that as well. A number of members made reference to the principles of tribunals, and I think it really was an issue that people kept coming back to. There have been a number of suggestions. I know that the Minister actually wanted to hear what some members were saying about that, and we've had some good suggestions. Here we, of course, have the suggestions from the Citizens Advice Bureau, which are reflecting the provisions in the UK legislation. And I think all members who have taken part in the committee have reflected on the importance of protecting the character and nature of tribunals, because far more people will experience administrative justice through a tribunal that will enter into the civil and criminal court system. And as we know, the majority of people attending tribunals do so within the reserved system. But it is important, because most of us, I think, do want to see all those tribunals coming over into the Scottish system, that Scottish legislation is able to be drafted in such a way as to bring those tribunals in. And I would say to Colin Keir, I do not think it requires a yes vote next year in order to make that happen. I think the Minister agreed with the committee. I know she was keen to look at that. But I also would say that I don't think anybody is suggesting a tight definition be incorporated into the bill. Tribunals, as we have heard, have been formed according to the needs and circumstances. They perform different functions. But they have characteristics of user-friendliness and others, which people have mentioned, which do need to be preserved. And it is those character and nature that we need to maintain, and that would be covered by a definition of principles rather than a rigorous definition. And I was pleased to hear that the Minister is interested in hearing more of that. I also wanted to reflect on a couple of issues which were raised with us in briefings prior to the Stage 1 debate, but weren't actually things that were raised with us in evidence. I think they may well be interesting. I don't know why they weren't raised in evidence with us earlier on, but I think that certainly they're interesting things to look at. The Citizens Advice Bureau this week also flagged up to committee members that there was an additional issue of concern, and that being the independent review of tribunals. The Administrative Justice and Tribunals Council is abolished, and with that its remit to keep under review the administrative justice system. Now, the bill makes provision for the Scottish Civil Justice Council, or the SCJC, to review practice and procedure and to prepare draft civil and tribunal procedural rules through amendment to the Scottish Civil Justice Council and Criminal Legal Assistance Aid of earlier this year. But that Act charges SCJC with keeping the civil justice system under review and to provide advice and make recommendations to the Lord President on matters relating to the civil justice system. However, there's no requirement for anybody to do the same for the administrative justice system. Process and procedures can be reviewed by the SCJC, but not the administrative justice system as a whole. Nor can the SCJC make representations or provide advice on administrative justice matters to the Lord President. So what Citizens Advice Bureau have recommended is that we give consideration, and we can do so at stage 2, to the SCJC having the functions relating to the administrative justice system equivalent to those it already has with respect to civil justice. And I would be interested, I don't know if the Minister has seen Citizens Advice suggestions in this regard, but I would be interested to hear her views on that. Environmental organisations such as Friends of the Earth, Scotland, Scottish Environmental Link and RSPB have for some time argued that Scotland does not comply with the United Nations Economic Commission for Europe Convention on Access to Information, Public Partnership and Access to Justice in Environmental Matters, which is also known as the Aarhus Convention. This, as members may know, has 3 pillars: the right of access to environmental information held by public authorities, the right to participate in environmental decision-making, and the right to review procedures and challenge decisions made by public authorities. And currently, decisions can go to a judicial review on a point of law, but there is no right to review the merits of the case. So stage 1 of the tribunals, well, is certainly not the occasion to argue whether or not Scotland is in compliance with the Aarhus. or could end up in an EU court, as RSPB are saying. But an environmental tribunal could be a mechanism of actually addressing the issues which are raised by the Aarhus issue. In fact, the Environment Minister suggests that this could be so in evidence to the Rural Affairs, Climate Change and Environment Committee on the 5th of June this year. He stated he intended to set up the appropriate tribunal in regulations once the Scottish Government knew the landscape of the new tribunal system for Scotland. So environmental organisations like Friend of the Earth suggest that as Government already intends to set up an independent tribunal to hear appeals on environmental monetary penalties arising from the Regulatory Reform Bill, this could be an opportunity to consider the creation of a wider environmental tribunal. So we may actually be seeing, not in the not too distant future, the legislation being used in the creation of a new tribunal rather than just in the transferring in of other tribunals. The number of people made reference to what we have variously described as the judicialisation of tribunals, or indeed courtification, although in committee we weren't quite sure whether we'd invented a new word in using that. We were concerned that any judicial members appointed to a tribunal may not have the necessary experience to fully understand the differences between a tribunal and a court, and I think that would be helped, in certain instances anyway, by the definition being clearer on the face of the bill, and yet another argument for that. I also noted in the Minister's written response yesterday to our report that she states that she intends to use composition orders to specify which type of tribunal member is required for which type of case, and therefore look forward to receiving more detail regarding how these composition orders may be scrutinised. Several members raised issues of concern around fees. John Pentland, Sandra White, Graham Pearson, Lewis MacDonald, and in particular, Lewis MacDonald and John Finney spoke about issues around employment tribunals, and John Finney expressed the view, the wish that we may be able to take these into the Scottish system and address some of the issues that happened through the charging of fees. I'm sure there is no intention here to introduce the type of issues which have happened in the UK employment tribunals, but certainly it might be something that could be addressed should some of those tribunals be transferred into the Scottish system. It would give us more control over issues like the charging of fees. I know that appears already to be causing problems for people who wish to go to employment tribunals. That's very much to be regretted, and there may be opportunities as we go forward to address some of those issues. Thank you.
Many thanks. And to now call on Rosanna Cunningham to close the debate. Minister, you have until 5 o'clock.
Thank you, Presiding Officer. Could I start by thanking all the members in the Chamber for a stimulating debate on what in reality is an important area of reform. And I particularly thank those sitting on the Justice Committee for their constructive contributions. Could I also make a sort of tiny point at the start of this as well, which is that when I was talking about composition orders, some people may have heard me or may have heard it sounding like compensation. So I just want to be absolutely clear that what goes into the record is composition, not compensation. Can I say that we have missed something in this afternoon's debate, and one or two of the members have referred to that, and that is that we have missed the presence of David McLetchie. The truth is, however, I feel his spirit is with us today. Because I can envisage him sitting with a cigar, watching our proceedings right now, with heartfelt thanks that he's no longer required to contribute. I do feel, however, that it is only right that I remind the Chamber that the last time we debated this subject, so impressed was Graham Pearson that he put on the record that he felt that David McLetchie possessed the attribute of glamour. I just feel that it's important that we reiterate that particular thing on the record. Now, it's clear from the debate today that members across the Chamber do agree that tribunal reform is long overdue and do have a desire to create a tribunal structure that is fit for the devolved landscape in Scotland. If I can go through some of the members' comments, I'll try to get as much in as I possibly can. Elaine Murray, and I think also Colin Keir, Rod Campbell and a fair few others did raise the issue of the Lands Tribunal in respect of the proposals that we have. And a number of people made the point that they felt it should more properly be regarded as a court rather than a tribunal, and I think that's something that has been said by a number of people. Well, it may be true that the Lands Tribunal is the one tribunal that does look most like a court, and I don't think perhaps anybody would depart from that. But it isn't a court. It is a tribunal. It's a tribunal in legislation, and it has one very key attribute that tribunals have, which is that it has lay members on its panels, which being a court would pretty much rule out. So the idea that somehow it can't be a court because of the lay members, it is a tribunal in legislation, and the lay members on that reinforce that idea. So I do think we need to kind of just remind ourselves about that when we're talking about this whole area. So that, you know, our desire to see the Lands Tribunal in, we have made a proposal about where it would fit in, and we still believe on the part of the government that that it needs to be there with the other tribunals. The point about tribunals is they are each and every single one of them different. And actually, despite some of the concerns and fears expressed by people, nothing in this bill changes how the individual tribunals operate in any way, shape or form, nor is there any desire to do so. And as new tribunals are discussed and perhaps legislated for, they will each of them have their own very particular ways of working, which again this structure will simply absorb. And that is as it should be. And can I also confirm to Elaine Murray on the slightly related point that chamber structures will be made by affirmative SSI, so that when we come back to that, that's how it will happen. Now, Margaret Mitchell did remind us that some 80,000 people use the tribunals every year. That's a lot of people. And they are generally overlooked when we talk about the number of people that go through the court system. That the reality is that the tribunals probably see far more people than the courts do. And can I gently point out to Stuart Stevenson that there is nothing at all quasi about the judicial decisions made by tribunals, and he should not use that term. They are making judicial decisions. John Pentland, in a sense, he recognised the balancing act that this bill is, and I think most members of the committee have understood that we are trying to operate a balance here with a better structure, a more efficient way of managing the whole framework, but nevertheless keeping the individual nature of the tribunals quite clear-cut. Colin Keir made reference to the children's hearing system. I would agree with all of his comments, which is, of course, exactly why the children's hearings are not listed in the schedule of the bill. So, you know, we're having some, and perhaps it's about padding out one's speeches to raise things which are not actually going to happen. But the danger with that is that that then perhaps creates a concern in other people's minds, and I don't want that to be the case. Children's hearings are not in this bill, and they're not there for a very good reason. So building a structure that is flexible to cater for the many different tribunals in Scotland is challenging. I think we achieved the right balance in the Tribunals-Bill. The bill creates a simple, clear structure, making it easier for tribunal users to navigate their way through the tribunal system. And I'd like to take this opportunity to reiterate my commitment to ensuring that the unique characteristics of all the tribunals transferring into the new structure will be protected. I know how important that is to those who are involved with these tribunals. It is in everyone's interest that the aspects of the current system which are valued are maintained and strengthened in the new structure. And this includes the expertise, flexibility, sensitivity, specialism and the ethos of individual tribunals. There is nothing about what the government is doing that is about interfering with any of that. Now, I hope the safeguards in the Tribunals Bill I have already spoken about today have gone some way to reassure members that these characteristics can and will be protected. The different leadership roles of judicial office holders in the new structure, for example, the Lord President, the President of Scottish Tribunals and Chamber Presidents, will provide an important mechanism to safeguard the particular and distinctive operations of individual jurisdictions against any unintended drift towards more generalised arrangements or dilution of specialism. Now, the committee convener and others, including John Finney, spoke about the position of the President of the Scottish Tribunals. I've made a point about saying that that is not an appointment. An appointment is a particular category of of what a government does. This is not an appointment. It is within the Lord President's hierarchy because it will have delegated powers from the Lord President. So it isn't a judicial appointment. It isn't an appointment in the general sense of the word. And if it's going to have delegated powers, then it does need to flow directly from the Lord President. At the same time, we would expect the judicial leadership to work together across jurisdictions to bring coherence to the system where this will benefit the delivery of a high-quality service to tribunal users. The new leadership structure will also provide opportunities for tribunal members to share best practice and learn from each other's knowledge and experience. Members have mentioned the number of tribunals which are not being transferred in. And I accept that the creating and transferring in of tribunals to the new structure will not happen overnight. And obviously there's a landscape of reserve tribunals out there which have also got to be considered in the future. At the moment, that is not our decision, and I think that what we're trying to do is create a framework that will be flexible enough to allow the transfer in if and when required. This is a technical bill. It's providing a framework for the creation of a cohesive system for tribunals as a whole. It is designed to be a manageable process, as it will take time to bring in each of the individual tribunals, and I would remind members that there are other policy areas within which the creation of tribunals is being discussed, and I think Elaine Murray mentioned one or two of them, but they're not the only ones, so that we are talking about an increasing number of potential tribunals on the landscape. Now, it's partly due to the complexity of the tribunals involved and the attention to detail that will be required to ensure that the system works effectively that it will take time to bring them in. We've therefore ensured that there will be a high level of parliamentary scrutiny for the majority of secondary legislation attached to this bill.
Order, please. There are too many conversations.
We want to get this right. We want to get it right first time, with no disruption to the service provided to the user, and I'm confident we can do this. Now, before I finish, Presiding Officer, may I draw the Chamber's attention to Just News, which is the Administrative Justice newsletter, which can be found on the Scottish Government website. It is of use and of information, particularly to committee members who may not know about it. But I would advise people to have a look. Tribunal reform is long overdue. Many expert reports have told us this over a long period of time. The Chamber has debated the issue twice previously. There's cross-party support on both occasions. It is quite simply now the right thing for the people of Scotland and the right thing for this Parliament to do.
Thank you. That concludes the debate on Stage 1 of the Tribunals-Scotland-Bill, and it's time to move on to the next item of business, which is consideration of two Parliamentary Bureau motions. And I would ask Joe Fitzpatrick to move motion number 8225 on committee membership and motion number 8226 on substitution on committees.
Moved.
Thank you. The question on these motions will be put at decision time, to which we now move. There are three questions to be put as a result of today's business. The first question is that motion 8145 in the name of Rosanna Cunningham on the Tribunals-Scotland-Bill be agreed to. Are we all agreed? Yes. The motion is therefore agreed to. The next question is that motion 8225 in the name of Joe Fitzpatrick on committee membership be agreed to. Are we all agreed? Yes. The motion is therefore agreed to. The next question is that motion 8226 in the name of Joe Fitzpatrick on substitution on committees be agreed to. Are we all agreed? Yes. The motion is therefore agreed to. That concludes decision time, and I now close this meeting of Parliament.